Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Be seated. Welcome to the Fourth Circuit. Panel this morning, to my right is Judge Harris, Judge Heitens to the left. We have 4 cases for argument today. Counsel are ready to proceed. We begin with the case of Charlotte versus Scott Brenneman. I probably butchered those names a bit.
It's pretty close, Your Honor. Good morning, and may it please the court, George Clark for appellants. You're sitting in your family home on your favorite armchair, well worn by generations. Refrigerator stocked, your kids' best bedrooms are festooned with the current fad of cartoon characters. Even the cat's happy. But the government says you need to leave. It's in the interest of public health. Not necessarily your health, but the community. Nobody doubts that that's a taking, okay? A fundamental right is taken away from you, totally disrupts your life and the lives of your children. Of course it's for a public purpose.
Is that the measure of a taking if a fundamental right is taken away from you? I thought it had to be private property.
It has to be property.
It has to be private property. The
It has
Takings
to-
Clause only says private property.
It has to be private property, Your Honor. The
So
question,
your analogy is the school your private property?
access to public school is private property.
Can I ask you a question that
Sure.
strikes me as getting to the heart of this? Has they might have a substantive due process claim? Do you know any court has ever said that an expelled student has a takings claim?
They have never said that, Your Honor. They've said
Isn't
it's...
that pretty significant, considering that schools have been expelling kids for decades? Someone probably would have thought of it. If that could be viewed as a taking, someone presumably would have thought of that by now.
Well, it's due process, Your Honor, and it's definitely a property claim.
I agree
for
you'd have a due process claim here, too, but you didn't bring a due process claim. You brought a takings claim.
Well, the question, I think practically the question is there a difference in whether something is private property for purposes of the due process clause and for purposes of the takings clause?
But that's not the question.
Due process clause doesn't require private property, only the takings clause does.
But Goss versus Lopez, the Supreme Court said that a student's right to education is private property. Very clearly, the Supreme Court said that.
No, they said there's a protected property interest.
It is a property interest, and it must be their property interest, Your Honor. I mean, it can't be anybody else's.
So what is your answer to the expelled student? Does he in fact have a takings claim?
I think he could have a takings claim. I think
Snow
typically...
days? What about snow days? Takings claims?
I think at some point, there's enough flexibility in the system that you're not removing the entire right that someone has. And there's a lot of...
There are partial regulatory takings.
Sure, but Your Honor, that's relatively narrow, and those rules are, you can have a lot of regulatory control over something in the takings case, and you don't take
A
it.
snow day does in fact deprive you of a private property interest, but you might still, for some other reason, not be entitled to compensation.
I think that's right, Your Honor. I mean, I think it is, you have this right, and the question is, was that right actually taken from you or not taken from you? And when I think the practical question here for me is, does a right that is given to you by the Constitution of Virginia, does that mean anything?
Well, it means you have a protected due process claim.
But the problem with the due process claim, Your Honor, is think about COVID. This emergency just happened. It takes years to go through that process.
I'm sorry, the fact that you might prefer the remedies available or the time frame under one clause of the Constitution as compared to another, I don't think that means that you necessarily, therefore, should consider this a takings clause case and not a due process case.
But there's no enforceability. The reality is that if it's just a due process claim, there's no enforceability. You wait, the school board can do whatever they want, eventually you come back in to school, so what? No harm, no
So you
foul.
mentioned a right under the Virginia Constitution. One obvious option that occurs to me is if you think these schools were violating your Virginia constitutional rights, you could have sued under the Virginia Constitution, right?
Could have, Your Honor.
And why wouldn't you? I suspect I know the answer, but
We viewed this case as a takings
I
case.
suspect the reason is that I suspect there's no plausible way the Supreme Court of Virginia was ever going to hold this violated the right to education of the Virginia Constitution, because most state courts, most states that have rights to fundamental rights to public education have said there's considerable flexibility in how that's provided. And I suspect that you could have never gotten retrospective relief under the Virginia Constitution either, because there would have been sovereign immunity and the only relief you could have gotten would have been forward-looking equitable relief.
Your Honor, I think the question is there a fundamental right under Virginia law for a child to have an
It
education?
just seems a little bit weird, you know, like, this is like Paul versus Davis adjacent to me. It just seems a little weird to say that if by hypothesis, the problem is that the remedies you could get in state court for violations of the state constitution are not the remedies you wanted, that you can then turn around and sue in federal court under the federal constitution. I mean, like, there is a whole line of cases that say the federal constitution is not a workaround to enforce state law rights that otherwise aren't enforceable in state court.
And I'd agree with that, Your Honor. I think the question is it a take? If it is a taking, though,
Sure.
then it's definitely governed by the federal constitution.
100%.
And that's what we're trying to figure out. And I think the question is, do you think that you can have a fundamental property right? We know those things are true. It is a fundamental right under Supreme Court precedent in Virginia. It is a property right under Goss versus Lopez, but it's not somehow vested enough to be a property right for takings clause purposes.
The
That's
differentiation, though, may well be, because you've identified the issue, and I appreciate you going directly to it. We have this issue before us, whether the right to a public education in the state of Virginia is a right that is recognized under the takings clause. You refer to a fundamental right. I'm not sure a fundamental right is what's protected under the takings clause. It is a private property right. That's different. Do you not agree?
I agree with you, Your Honor. I think Goss
So
versus
it's not just a fundamental right, it's a private property right. In order to be able to get there, you have to satisfy what would in fact constitute a vested private property interest.
I agree with that, Your
And
Honor.
as of the date, I don't know of any court that's ever said that this particular interest is one that's under the takings clause. Do you?
There isn't one, Your Honor.
Not one.
Not one.
Since this country was founded, or since Virginia had its constitution.
That's correct,
So
Your
why
Honor.
should we now, out of, want of a better term used by one of my colleagues, out of whole cloth, create such an opportunity for you now?
Well, I would say to you, Your Honor, COVID was a very unique circumstance. And taking away somebody's right to an education
But
wasn't really...
expelling kids is not a unique circumstance. It's been going on for decades.
But expelling kids, Your Honor, there is typically a pretty fast response time for that. That was not the situation here. It was impossible for there to be a fast response time. The school district would not let this child back in, these children back in, would not let them back in because of this health emergency.
Right.
It wasn't like you could go...
Why couldn't you have gone to court and sought injunctive? I'm not saying it would have succeeded, but why couldn't you have gone to court and sought injunctive relief? People bring, I mean, I think we can take judicial notice of the fact that lots of people sought fast-moving injunctions during the pandemic against aspects of lockdown that they claimed violated their rights. Lots of people sought emergency relief.
I agree.
Why couldn't your clients have done that?
Your Honor, that is possible that by the time we were engaged and we went through this entire process, we could have done that. That's possible. The reality is by the time we got engaged and things started to move and anybody was doing anything, we were already well into this process. And I think the question is not could we have done something else, but is what we did, and I think is what we did enforcing a property right.
Well, but I guess the something else seems relevant in this regard. One of the arguments you make in your brief, which is a fair argument, which is like if you don't recognize a takings claim here, there's literally no consequence for violating this right. That is a pretty prominent argument in your brief, is that if you don't give retrospective damages here, schools can do whatever they want and there's no remedy. I mean, I guess I've just identified something you could do, which is you could bring a claim while it's going on and seek injunctive relief. That's something. And now there's maybe reasons why you didn't do it, but it seems to me it's a pretty strong counter argument to the unless we have this takings right, there's literally nothing you can do.
I think after the fact, when you had a global pandemic, which I think we need to bring ourselves back to that, a global pandemic where even courts were shut down sometimes, okay?
Not from hearing cases. This court was open. The district courts in this circuit were open. There was never a point at which the courts were shut down.
Your Honor, the practical reality of it was that there was not real movement in in a lot of different legal systems. I mean, this is what I do for a living too, and I know that there was a lot of restrictions.
But the focus you really, alternate opportunities, we all tend to think if there's a wrong, there should be some remedy. Really, it's not our question here today. The only question is that remedy under the takings clause? If it's not under the takings clause, we don't have to explore, is there some other way you could have done this? It's gratuitous, and because we tend to agree with you that if something's wrong, there should be some way to explore it. Judge Hyden has rightfully pointed out there may be other avenues to do it, but ultimately the only issue before us, does this arise under the takings clause? Is it a private vested property right that is cognizable under the takings clause?
Your Honor, I completely agree with that. That's exactly the question, and I think...
Your answer is yes, but
Yes.
You're the only one that's saying it.
Well, I've got Goss versus Lopez, the Supreme Court saying it's a private...
procedural due process case.
But it is property.
Can I ask you a question, and it's sort of about the posture of this case? I understand, giving you a hard time, that's what we do, but I understand your argument that under Goss versus Lopez, there is a property interest under the due process clause, it's a fundamental right, and it follows from that there is a private property interest under the takings clause. But if you would just assume for a minute, hypothetically, I don't agree with that theory, did you allege in your complaint or plead any other theory under which this might be private property?
Any other theory? I don't think it could be private property under any other theory, Your Honor. I think that is the basis for it being private property. And again, just to be clear, it is access to education. You have, and I'm not going to go on the facts a ton, you have severely autistic children who need a routine, who need to be in a space that they're familiar with to learn. And defendants took that space and allowed other people to use it, okay? And so that is the fundamental, that's our fundamental factual argument, not to waste a lot of time on facts.
Takings would apply regardless of what their state of being would be. This would apply to any child whatsoever. Is that correct?
Your
Or
Honor,
does it matter that this particular child had special needs?
I think,
Oh, go ahead.
I just want to hear that.
I think the question is, practically, for many children, there was no taking because virtual education worked for them. So what was taken? Nothing was taken from them, right? Would they have liked it to be a different way? It's fine, okay? But when you have kids where the access
Or they
to,
could come up with various other reasons to say that virtual is not the same as being in person. Maybe not as stark, but nonetheless, it could say that there are certain children, just they might respond better in a class. The discipline would be different. They could maintain, if you have such a claim, don't you think?
Your Honor, I'm sure somebody could come up with something, but I think at the end of the day, there is this flexibility on what is a taking and what isn't a taking, and there's a lot of case law in that space, right, where restrictions, basic restrictions for easements and things like that sometimes are taking, sometimes they aren't. Regulatory, there's a lot of leeway in that space. Whereas if you have something completely taken away and these kids really needed this and were extremely disrupted, that's a bit different.
Why isn't that just an IDEA claim? That seems like a classic IDEA claim, right? I mean, based on the facts you allege, it seems like you have a plausible IDEA claim, which is that schools, in the course of trying to deal with the global pandemic, had to decide which students could go to school in person and which ones couldn't. And they decided, for reasons that may have seemed sufficient to them, to not allow kids with certain disabilities to go to school for reasons that they thought. And you might say there's a federal law, the IDEA, that says that you can't do that. Like, this just feels like a classic IDEA claim.
I mean, that's not the remedy we're asking for, Your Honor.
Because you can't get compensatory damages under the IDEA either, right?
That would be correct, Your Honor.
But you can get compensation for remedial services, right, under the IDEA?
You can, and to the extent that the government actually was providing those, then that would be mitigation.
No. You can, if a parent who is deprived those services goes out and pays for them out of their own pocket, one possible remedy under IDEA is to get paid back for those sometimes,
In
right?
theory, Your Honor, sometimes
That
in
is an
practice.
available remedy.
It is an available remedy, Your Honor.
Okay.
Not necessarily in practice.
Fair enough.
No, I guess the only other thing that I would cover, I think we've had a full discussion about this, is this lack of measurable value, okay? The district court focused on this not being a measurable value. We try complicated cases all the time. in front of district courts on very, very obscure questions of what value is, from tax cases to patent cases to copyright cases to general damages cases. Will it be complicated to figure out what the value is? I have no doubt it will be complicated to figure out what the value is. But I also have no doubt that Judge Strenga is perfectly able to figure out what the value is.
We'll hear from your other counsel, and we'll give you some time to respond to the
Thank you.
counsel there. Thank you for your argument.
May it please the court, John Cafferkey for the appellee, Dr. Scott Brabrand. With me at council table is my colleague, Ian McElhaney, who's been involved throughout this case, which has some history. It's clear that you, members of the panel, have fixed on many of the issues that we raised in the briefing. So rather than repeat that, I want to hopefully respond to a couple of things that came up in your questioning, and also make a couple, or emphasize a couple of
Let's go straight to the issue.
additional points. Yes, sir.
Where's your case?
Come again?
It's a pretty simple case in terms of the legal side of it.
Well,
I mean, we can dance around it, but the issue comes down straightforward. Is this a claim cognizable under the takings clause?
well,
That's all we need to hear, because that's all we're going to decide basically on this, unless we go somewhere different.
And I would submit to you that the Ninth Circuit's decision in the Zion case, which similar in many respects to this one, is the only, at least appellate level decision that we have been able to find on this issue. And the analysis tracks very much many of the points that we made in terms of whether it is, this is the type of right, the property right that is conferred by state law, that's one of the conventional types of property rights that's recognized by state law.
So can I ask you about the one place in which the Ninth Circuit's approach seems hard to square with what we've said? So one of the things the Ninth Circuit said is that it's not vested. The problem is that this court seems to have said several times that constitutional rights are necessarily vested. So the Ninth Circuit draws this vested, non-vested distinction. The problem is, now, albeit, I think in the due process context, but there's several statements from this court that seem to say constitutional rights are, by definition, vested. So if we're going to write an opinion that says it's not vested, we have to figure out what we're going to say about our decision saying there is no such thing as a non-vested constitutional right.
I would focus, I think our understanding and interpretation of what the Ninth Circuit said there is simply that it is not the type of property right that is recognized for purposes of the takings clause, rather than it's, so.
But they did use the language not vested, right?
Fair enough, Your Honor, and the jurisprudence in Idaho also is to the effect that they don't describe the right there, and this is a point made in the briefing, as a fundamental right. But when you look actually at what the case law that they rely on there, they're really saying actually the same thing as the Scott versus Commonwealth case, one that's talked a lot about in the briefing, which is that what you have is a right to have the state General Assembly or the state legislature develop a system of free schools. You don't have an individual right, and certainly you don't have a property right.
Just one more question about this vesting point.
Sure.
You agreed the district court also used the word vested. Like, one of the things the district court said is that their rights weren't vested. The decision under review.
Fair enough. I wouldn't, I don't think our position depends, frankly, upon whether the right would be considered vested, but simply whether it's recognized as a property right under Virginia law, either statutory or constitutional law.
Well, it's definitely a property right for purposes of the due process clause, right?
I wouldn't disagree with that.
So, I'll just give you a really tangible example, right? There are constitutional limits on a school, well, assuming there is a due process right to education. There are due process limits on your ability to expel a student or to suspend it. Is it 10 or 4? How long can you suspend a student?
10 days. And Your Honor, Mr. McElhaney and I just had another case in federal court in the Eastern District on exactly that issue. I wouldn't disagree.
So in other words, it's clear that for purposes of the due process clause, students in Virginia have a vested property interest in public education.
I wouldn't disagree with that.
That's why, that's the
And-
reason you have hearings for expulsions and suspensions.
Correct, and there's also specific statutory protections for that as well. One thing I did want to, so I've answered that question. One thing I did, there's a lot in the complaint, and Your Honor, to get to your question, or to several of your questions, even though it's true that the three plaintiffs here were all students with disabilities, the IDEA, the fact that they are, is completely irrelevant to the legal analysis here. In fact, as we pointed out, one of the three plaintiffs actually pursued a separate IDEA claim in first the administrative hearing and then in federal court, Joint Appendix 151, I think the footnote of recognizes that. So there were a lot of other avenues here. The most straightforward one would have been an IDEA claim.
It seems like a classic IDEA claim, right?
Correct. And in fact, there are, over the last 4 years, in fact, we have another, there'll be another argument to this court on Friday concerning IDEA, among others, IDEA claims in the context of school shutdowns for COVID reasons. But the fact that these students were students with disabilities is completely incidental to the question of whether they have rights not to have to, that providing virtual education to them is a deprivation.
He says really it's because of their disabilities that they're unlike other children who may not experience the kind of negative situation with a virtual learning, that because of their particular status and who they are not able to benefit from this educational process, and therefore it is a taking for them.
Well, it's...
Now, granted, the IDEA provides a remedy. It seems like there's definitely a cross-section here, because that's pretty much what happens in regular school situations where you bring a claim like that too.
Well, right, it could be a claim under IDEA. It could also be a claim under Section 504 of the Rehabilitation Act. It could conceively be, that's a discrimination claim.
But tell me,
and that's not what you have
do you
here.
maintain that vested under the takings clause is different than vested with regard to a due process claim or a zoning claim? Is it different?
Well, what's different is the nature of the right. As has been said already, there are many cases involving procedural, and this court's jurisprudence and that of all the circuits in the Supreme Court are to the effect that there's a fundamental difference between rights that are protected under the procedural due process clause versus the takings clause. So the nature of the right is different, and for purposes of takings jurisprudence, much narrower. It has to be a property right, it has to be private, and it has to be taken. And as we said in our arguments, none of those three prongs are met here. As to the taking, virtual provision or virtual education, it may not be perfect. For a lot of students, it wasn't perfect, but it wasn't a complete deprivation of education. And under the Virginia system of providing education, in the first instance, it's up to the Board of Education and then the General Assembly to decide what the standards of quality are going to be. I mean, frankly, it would be consistent with the Virginia constitutional scheme for the Board of Education and the General Assembly to decide we're going to have a system of virtual education for all students going forward. I'm not saying that we would recommend that, but...
and if people thought that violated the Virginia Constitution, they could challenge that in Virginia State Court. Right.
Absolutely, Your Honor. So there's not a taking, it's not... it's not private. This is not, and has been stated already, the public nature and the public control over education in Virginia is at all stages, from the creation by the General Assembly and the Virginia Board of Education to the implementation by local school boards to the regulation of that by the General Assembly. There's a whole, live with it every day, Title 22.1 is the General Assembly's regulation of the education process, to the Virginia Constitution, Article 8, Section 7, which says that local school boards have essentially plenary control over the provision of education, to the General Assembly or the Virginia Board of Education could change the standards of quality. That wouldn't be, that would be a regulatory, action that would not deprive students, we would say, of a property right under the takings clause. And the sort of the last section of the argument and the briefing that counsel makes, particularly in the reply brief, is a number of policy arguments. But I would submit to you, think about the implications.
Let's stick with the law here.
Oh, fair enough. But
Let me ask you to
we've
pause.
explored that in the
because
briefs.
I want to ask my colleague something. I think we're fairly satisfied in terms of where your argument is going, and appreciate it. We'll hear from the other side. Give you a chance to respond.
Understand, I don't want to speak the one word too many. We've addressed these. in the
There's a
briefs.
danger in
Thank
that.
you, Your Honor.
Thank you. Mr. Clark, you have time to respond.
Thank you, Your Honor. So I'd like to go first to Zion and the question of what Zion found and said. If we go to 1143 in Zion, the public version, or the published version, it very clearly says, by its very terms, the Constitution of Idaho does not on its own create the public school system. It's a mandate to the state through the legislature to do so, citing Thompson versus Engelking, which is the Idaho Supreme Court case that very clearly says that the Idaho Constitution, quote, does not establish education as a basic fundamental right. That's what they're relying on. They're relying on that Idaho Supreme Court case, which is directly contrary to the Virginia Supreme Court case that says, quote, education is a fundamental right under the Virginia Constitution. So when I look at this, I say, we've also got the Bill of Rights, the Virginia Bill of Rights, Section 15, Article 1, Section 15.
But I want to make sure we're talking the same. I can let you continue, but the differentiation I'm seeing here, and maybe my colleagues might agree or not, is you keep referring to a fundamental right. That's not what's necessary in order to be under the takings clause. You need a vested private right.
I agree with that.
Don't you agree that's different in character than just simply the broad fundamental rights? Covers a lot of things, but a vested private right is a bit more specific, a little narrower, wouldn't you say?
Your Honor, we're lawyers. We deal with words all the time.
But those words are important because that's what's necessary for you to get a claim under the takings clause. I understand we deal with different words, and sometimes we go back and forth, but those are pretty straightforward words.
Well, I would say I've got Goss saying I have a private property right. I've got the Supreme Court of Virginia saying.
Where does Goss say that?
Private. It says it's a property. It must be the student's property, right?
No. So tell me where in Goss it says.
It doesn't use the word private, Your Honor.
That seems like a really important difference.
But it can't be a different kind of right. It's their right.
But the word private, I mean, we're all kind of textualists now, and the word private appears in the takings clause.
It does, Your Honor.
It doesn't appear in the due process clause. So why do you think it doesn't make a difference whether the property interest for that issue is private?
I don't think it doesn't make a difference, Your Honor. I think when Goss is talking about a student's right relative to the education system, how can that be anything other than their right? And it must be private. It's private to them. It's not some abstract right that isn't theirs. They're the ones that got kicked out. They're the ones that are saying they're coming back in. How is that not their right? So I've got their right. It's a fundamental right. So the question is it a vested right or not?
Well, it seems like a really weird private property right. Can you sell it? Can you transfer it? Can you assign it to somebody else? This is a weird, if we think, like, when I think of the classic property bundle of sticks, this is a weird right?
There's a lot of weird rights, Your Honor. I mean, a lot of the intangible rights are very strange. I mean, you have a right to exclude certain people in copyright, not other people in copyright. You have easements that sometimes you have a right to exclude people, sometimes you don't. I think it's complicated. And at the end of the day.
I can sell a copyright, I can assign a copyright, I can sell an easement, I can assign an easement. I can inherit an easement.
What? You can exclude somebody else from your public education. We talked about that in our brief, right? If somebody else tries to check in as you in public education, they can't. You have a right to that. You have a right to, not take a public education instead go to a private education. You pay for things, right? Property taxes funds all this. That's how the system works. So I think.
Like if it were, I'm trying to think of fundamental rights that are personal, like perhaps the right to marry. You think that if the government violates my right to marry, I can bring a takings claim?
Your Honor, to the extent you had damages, yes. The reality is the reason why we don't see these cases is because the government doesn't do this. The government doesn't.
The government doesn't violate the fundamental right to marry. I mean, it did apparently until very recently.
Well, if we're
Until
talking.
Burger fell, we were violating all kinds of people's fundamental right to marry.
Fair enough, Your Honor. I guess nobody thought about bringing it as a takings claim. But I would say to you, if you have a right to a jury trial, it's not like we say, oh, well, there just weren't that many jurors that showed up today, so you don't get a jury trial right. You get a jury trial right. As a general matter, the state executives don't violate fundamental rights that are in the Bill of Rights. I mean, again, I think we go back to, this is a constitution we're expounding. We've got a right to education that is directly in the Virginia Constitution. Typically, and I think prior to now, there hasn't been a wholesale revocation of that right prior to COVID.
Thank you.
Thank you.
Thank you.
Mr. Clark. Thank you, Mr. Cafferty. We are going to come down and greet counsel and proceed to the next case. All right, you may be seated. The next case on the calendar, the United States versus Hunt. We will hear from the appellate's counsel.
Thank you, Your Honors. Excuse me. Steve Van Semfort for the appellant Matthew Hunt. And I'd like to reserve 5 minutes for rebuttal if I can. Thank you. So I think I want to start with framing the error that we're talking about, because I think that'll help kind of get through some of the standard of review issues that are potentially present in this case. So after Bruin and after Rahimi, it's very clear that the burden is on the government to look at the historical record and to abstract a principle that justifies the current regulation that's being applied against the government or against the defendant. So here, 922G1 as applied to Mr. Hunt. Now, the interesting thing here is that in Rahimi, the Supreme Court, it canvassed the historical sources that are exactly the same historical sources that the government looks at here, right? And it abstracted a principle that simply doesn't apply.
What we're dealing with. We're dealing with 922 here, and the issue goes to the question of whether we're going to continue to recognize that felons cannot really be carrying weapons around. I mean, you think that Bruin has changed that?
Yes, Your Honor.
And so you think that today you want to come and say, court, we need you to now authorize felons to continue to carry weapons, and that is going to be constitutional.
Well, Your Honor, I think we would have to.
Well, you say that's already the law because Bruin did that, because now we need to do a historical analysis.
Correct, Your Honor. So I think our position is that Bruin and Rahimi, they require courts to engage in historical analysis, and they require governments to carry the burden of demonstrating that the current regulation here 922G1, is consistent with historical principle. And I think that's pretty clear. I think, the Williams case from the Sixth Circuit.
First question we have to determine is, did Bruin do anything to our case law, which was very clear, before Bruin, it was very clear, you do agree with that? Very
Yes.
clear, you think Bruin did something to change that? Tell us how Bruin did that.
Yeah, so absolutely. So again, I think the Sixth Circuit in the Williams case talks about how Rahimi changed the law, right? Because previously under this court's law and under almost every other circuit's law, there was a two-step analysis.
I appreciate the citation to the Sixth Circuit in Williams, but we just very recently went out on banc in the Bianchi case, and we held that Bruin did not supersede our prior law regarding assault rifles. And so how would you distinguish this case from that?
Well, Your Honor, I think that Rahimi, right, underscores what Bruin suggested, right? So in Rahimi, you're looking at 922G8, which is, only a couple sections away from 922G1. And Rahimi underscored the fact that you need to conduct a historical analysis, right? You need to conduct a historical review. So I think Rahimi itself underscores the necessity for this.
Rahimi came down before Bianchi was issued, so I feel like we just had this question as an en banc court.
Right, whereas what the Fifth and Sixth Circuit said, basically echoing your argument, is that Bruin and Rahimi call for a completely different mode of analysis, so anything we said before those cases is no longer binding, and maybe that's an argument, maybe it's not an argument, but doesn't Bianchi just say that's not what we do here?
Your Honor, I concede that there are some hurdles to our potential relief in this particular case, and Bianchi may be one of them. I concede that it is, again, our position would be that Rahimi instructs courts to engage in historical analysis. If this court has decided otherwise, and if the court believes that Bianchi directs the court that the pre-Bruin jurisprudence is still good law, then
Not all of it, but the stuff we decided at step one.
exactly the step one. Yeah, if that's what the court believes, if this was the panel believes that Bianchi stands for, then I recognize that.
Can I take a step back? So you said you were going to tie this up to your preservation issue. So as I understand, in a nutshell, your argument is, like, these cases just came down. Like, how are we supposed to, that's good cause, right? But you agree, for example, under Federal Rule of Criminal Procedure 52B, the law changed and I couldn't have anticipated the law changes, does not under any circumstances you get out of plain error review under 52B, right?
That's correct.
So what authority says it's good cause under Rule 12?
Right, so we would rely on the Duarte case from the Ninth Circuit. I recognize, of course, that Duarte has subsequently been vacated. It's being reheard on banc, and I don't know what the Ninth Circuit's going to do. So that's the authority we rely on there. Again, I understand.
But how does that make sense? Just to say, like, failure to anticipate a change in the law is not an excuse under Rule 52, but it is an excuse under Rule 12.
Your Honor, the Ninth Circuit in Duarte, it based its rule based on its own prior precedent, right, which is exactly that.
I'm just asking you how it makes sense to say that for purposes of appellate review, failure to anticipate the law doesn't get you out of an unfavorable standard of review, but for purposes of district courts, it does.
Your Honor,
does that make, like, what sane universe would have that set up?
Well, and I don't know if this answers the question, Your Honor, but I think it is indicative that the government in its supplemental reply or supplemental brief here, in the last sentence, basically the government says, look, this issue is just a matter of law. It's an issue as a matter of law. We don't need to send it back to the district court because this court can do it anyway.
Yep.
And so then the question is, if it's just a question of law, then what utility does the preservation requirement have, right? If it doesn't have to be sent back down to the district court anyway.
You could say the same thing about all the people who forfeited Apprendi claims before Apprendi, who forfeited Elaine claims before Elaine. Like, I can make a whole long list. And you could say the same thing in all of those cases.
Your Honor, I don't necessarily disagree with you in the mine run cases, right? And I think that's where the class case is helpful. Now, again, I admit class does not talk about the standard of review. The government's correct about that. But I think class does make it an interesting scenario because class says, look, you can't waive, like, the argument that the statute of conviction is unconstitutional is something so fundamental that you don't waive it when you enter a guilty plea. So if you can't waive it because it's so fundamental, then I guess it begs the question, how can you forfeit it? If it's something that's so fundamental, how can you forfeit it?
Because you can forfeit, like, almost anything. So I'll give you an example. You can't waive the right to a non-biased trial judge, but you can forfeit an argument that your trial judge is biased, right?
Yes, you can. Yes.
Like, you can, I mean, what can't you forfeit?
Well, Your Honor, I guess that's the question, right? I mean,
Okay,
and-
that's totally fair. What's another constitutional right you can't forfeit?
Well, Your Honor, I think the argument here is that you can't forfeit the argument that your statute of conviction is unconstitutional, just like you can't waive it by entering a guilty plea, right? I think that's what class held, because what happened in class is that the defendant had an argument that his statute of conviction was unconstitutional under the Second Amendment as applied to him. He then entered a guilty plea, but it wasn't a conditional guilty plea.
But don't you agree that almost every court that's decided this question post-class has said, oh, it's not waived, we get that? So, two questions. The defendant in class had actually filed a motion to dismiss the indictment, right?
Yes, that's correct.
So he didn't forfeit it in the district court. The only question is whether his subsequent guilty plea waived a challenge
That's
that he'd
right.
already preserved.
That's correct.
So not the class situation, the situation like this, where the defendant doesn't raise it in district court. After class, hasn't virtually every court of appeals to consider the question say that claim is reviewed for plain error?
I believe that's correct. Yes, and I don't dispute that. Again, I would say that just because other courts haven't found it doesn't mean it's correct. Yes.
Can I sort of bring you back to the heart of your case, which is you want us to recognize as-applied challenges based on dangerousness of a felon, is that right?
So I think as-applied challenges are definitely on the table. So if you look at Rahimi itself, Rahimi involved a facial.
You're not making a facial claim here, are you?
Well, we made it, but then the United States versus Canada came down, and so we acknowledge that.
So now we only have an as-applied challenge.
That's correct.
Okay, and I want to know how you seem to think that the way that would work is that we would only look, we would ask whether it can be constitutionally applied to your client by asking what was the felony referenced in the indictment. And because that felony was not common law burglary, it's not necessarily dangerous, and so it's, okay.
Yes.
So what makes you think that if we are doing as-applied challenges, we don't look beyond the indictment? Because it seems like the other courts that have dabbled in this, the Third Circuit, the Sixth Circuit, they don't limit themselves to the indictment. They look at all the surrounding facts and circumstances, and your client has been convicted several times of domestic battery. And so it is hard for me to see, I mean, it's like Rahimi, but with the conviction. So it is hard for me to see after Rahimi how we could say this law is unconstitutional as applied to your client.
Well, I think the question is what was the basis for his conviction, his felon in possession conviction?
Why is that the question when you're doing an as-applied challenge? Usually we say, can it be constitutionally applied to this person, not to this indictment?
Yeah, no, that's an excellent question. So the question, I think, is can this law be constitutionally applied to him, right? And I think you have to look at how it was applied to him, right? The way it was applied to him was based on this particular felony conviction. Now, is it possible that if this conviction was vacated, the government could go back again?
In your view, the indictment. I mean, you agree, right, that that's not what the Third Circuit in Range or the Sixth Circuit in Williams is talking about.
Certainly the Sixth Circuit in Williams. I think the Third Circuit in Range, again, I think that's also pending en banc
All
again.
the facts that happened so long ago, he hasn't done anything bad since then, it was all the facts,
Yeah, I think that is part of the optics in Range, certainly.
part of the reasoning.
And I think that because when you're talking about the felon in possession count, right, the charge, right, we're looking at why he was convicted. He was convicted only because he possessed a gun and because he had this specific felony conviction beforehand, right? And that would be the specific felony conviction for the nonviolent burglary, right? Snipping somebody's lock out of his garage.
So you
Yep.
think the way we do this is we just look at the indictment?
I think you have to, because for example, the Williams case, I think that standard is, I mean, we'll see how it plays out in the Sixth Circuit, but it seems to be unworkable.
So that's another question I have. Yeah, I mean, I have serious sort of workability questions about all of this, and I know we're calling it an as-applied challenge, but it seems to me that once we start down the road of allowing as-applied individual challenges, we are actually effectively rendering the whole thing unenforceable against all but maybe a handful of felons. Because who has notice in advance of whether, if you need advance notice that what you're doing is illegal, and defendants will entirely justifiably say, oh, I thought I was the non-dangerous kind. I thought I was going to get the exemption under the Second Amendment. And the government's going to have to prove under Rahafe, not only knew he was a felon, but also he knew he was the kind of felon who would not be eligible for a Second Amendment exception. And I just think at some point, it is technically an as-applied challenge, but we better reckon with what we're talking about, which is you can't apply this statute to anyone.
Well, Your Honor, I mean, there certainly are lots of considerations at play here, and I think your points are excellent. I do think, in terms of an as-applied challenge being available, again, if we go back to Rahimi, Rahimi was a facial challenge, obviously, but in order to assess the facial challenge, what the court did is they looked at the statute as applied to the defendant there, right? And then they said, well, because as applied in this particular circumstance, we know that at least in one application, the statute is constitutional, and so therefore it's not facially unconstitutional. So I think Rahimi, I mean, it basically engages in an assessment of how does this statute apply to this particular individual, and it doesn't look at the specific facts based of Rahimi, right, of the defendant there. They said the defendant, he went through this process, right? The process requires that there be a prior adjudication of violence, and so that's what happened here. We don't, you know, the court didn't assess whether that the domestic restraining order process was, you know, correctly applied to him or not. It just said he went through the process, he had the opportunity, and that's enough. So they looked at the circumstances of the individual defendant there, the process he went through, and then said, based on the fact that it's constitutionally applied to him in this particular circumstance, the statute isn't facially invalid. So
What do you make of Rahimi, after Bruin, of course, citing with approval that hello dictum that essentially says that felon possession laws are presumptively lawful? What do you make of that? If Bruin got rid of it, and why in the world would the Supreme Court come right back and cite something they just got rid of?
Your Honor, and I recognize this is problematic for my plain error argument, but Rahimi isn't perfectly clear on some of these issues.
None of these cases are.
Well, and Your Honor, I guess I would point you to, again, the Sixth Circuit's decision in Williams.
But, I mean, go there, though. I mean, we agree with Hamilton, the law before Bruin. Hamilton, which is our case, is the law that binds us. That says felon and possession laws, basically they're good, okay? Then Bruin comes along, muddles it a bit. We've got Heller with this footnote that has this presumptively legal language in it. It's a footnote. Someone came along, called it dictum. And we know dictum can mean, well, that's not exactly the holding, might not be controlling. I never quite understood dictum from the Supreme Court of the United States, because if it said it, it might be dictum to them, but it seems like to me it's kind of binding on us. But nonetheless, they call it dictum, which means that maybe you can ignore this if you want to. But then the Supreme Court comes back in Rahimi and cites it. Repeatedly cites this dictum from Heller, that these felon possession laws are presumptively lawful measures. That's a tough one to follow. I mean, you know, and I get where you are, because what you're doing is arguing a case, and maybe you could end up back in the United States Supreme Court, which would then say, well, some felons can now walk around with guns. But if we follow our precedent, and if Bruin didn't overrule it, and if they recite it, don't you think it's pretty clear that we really don't have a choice in this matter, do we?
Your Honor, I see I'm out of time, if I can.
Certainly, just answer that.
Yeah, Your Honor, I agree the you know, quote dicta in Bruin and Heller and then Rahimi, I mean, they've said the same thing over and over. On the other hand, Bruin and Rahimi are very clear that the government has to engage in historical analysis in order to support the validity of a regulation. And if it's true for 922G8, it seems like it's got to be true for 922G1. I don't understand why the historical analysis would not apply to any other gun regulation.
Now, I'll come back to that question, because there is a question that you seem to be saying is that it doesn't matter what it is, we now have to do this historical analysis, no matter how obvious it is. We have to do that when we come to these cases. But we'll think about that.
Thank you, Your Honor.
We will hear from the appellee's attorney.
Good morning. May it please the court. Mahogany Reed for the United States. Mr. Hunt's conviction for possessing a firearm as a felon in violation of Section 922G1 is not plainly unconstitutional, and the district court did not clearly err in determining that it is more likely than not that Mr. Hunt discharged a firearm inside his apartment.
Well, the question before us is whether now we look at felon and possession laws as being presumptively lawful, or are we now obligated per Bruin and per the counsel on the other side perspective to now conduct a historical analysis. Doesn't mean he's gonna win it, even if we do that, but at least it puts it in a different posture than simply saying, well, we already have a law, we don't have to look at this. We know that a felon cannot possess because our law says that. But he says Bruin has changed that. How do you respond to that?
Well, I'll answer the question, and then I'll state why I think that's an improper framing of the question.
No,
But the
first, tell me why it's improperly framed.
Well, I think it's improperly framed because Mr. Hunt's challenge on appeal is not to the methodology that the district court did or did not engage in the district court. It's a challenge to the constitutionality of his conviction. So the question for plain error purposes is not whether the government was required to provide historical analogs in support of Section 922G1 to prosecute him. The question is whether Bruin and now Rahimi made it clear or obvious that his conviction is unconstitutional. I think the answer to that is clearly no.
Is that driven by us to make it a determination of saying it is plain error review?
That's right, Your Honor.
If it's not plain error review, then where does it fall?
Well, if it's not plain error, if this court determines that Mr. Hunt's conviction is plainly erroneous, is that the question?
We determine it's not subject to plain error review under the Ninth Circuit's now vacated reasoning.
Oh, I see. If you determine that the question is not subject to plain error review and decide to engage in plenary review, then no, you would still have to determine whether this court's pre-existing precedence is overruled or abrogated by Bruin, and we think the answer to that is no, because, you know, as Your Honor mentioned, Rahimi reiterated the presumptively lawful language in Heller that this court's pre-existing precedents rely on. And not only that, but Rahimi also went out of its way to emphasize that it was not suggesting that the Second Amendment prohibits legislatures from disarming categories of individuals deemed to present a special danger of misuse. And it's our position that Section 922G1 falls squarely within sort of that construction of the constitutional question. And so we don't think that Bruin or Rahimi abrogated this court's pre-existing precedents, but we don't think this court needs to necessarily answer that question in this case, because under plain error review, no decision of the Supreme Court, no decision of this court, and no decision of a consensus of courts of appeals have determined that Section 922G1 is unconstitutional either on its face or as applied
What
to...
did Heller mean by presumptively lawful? Could that language mean that you can bring an applied challenge?
Well, so this court recognized and has recognized in its decision, Warren Pruis, that presumptively lawful suggested that that Section 922G1 and other felon in possession prohibitions are lawful on their face and are susceptible to as-applied challenges. I don't know that Heller's presumptively lawful language meant that an as-applied challenge would succeed, and it's our position that an as-applied challenge would not succeed to Section 922G1 under sort of any analytical pathway. I mean, unless this court has further questions on the plain error question, I think this court can resort to the...
Sorry, I do have a question about the plain error thing. I understand the argument about class that you're making, but it does seem that there are courts out there, not ours, we have not done this, but that they analyze a forfeited constitutional challenge to an indictment under Rule 12, not under Rule 52. And so they apply Rule 12's good cause standard. And I guess I was just wondering if the government today has a position on whether Rule 12 somehow applies to appellate review and supersedes Rule 52 if we're talking about a challenge to an indictment.
Yeah, we don't think that Rule 12 supersedes Rule 52. We think that on appellate review, the question is whether the defendant had an opportunity to object. If the defendant did not object, then the question is subject to plain error review. Those circuits, and I think, you know, the 7th, 8th, and 10th circuits have sort of married the Rule 12 and Rule 52 standards in some cases, but they've reconciled them. So even in those cases, and the 9th Circuit is an outlier, I'm happy to discuss why we think Duarte's panel opinion, since now vacated panel opinion, is wrong. But the circuits that have married those two standards have said, okay, well, you know, to the extent a defendant can show good cause, then we will review his claim for plain error review. But where a defendant fails to show good cause, that claim is waived and therefore unreviewable.
Which is what we've kind of said, right? We've said that.
I think so. I'm having a trouble
So
sort
the
of
view is,
recalling the
okay, so
cases,
the view
but
is that if a defendant doesn't raise it before the district court and he can't show good cause, is that, I realize we've said that, is that the government's view?
that the defendant has waived?
Waived, like no review at all.
I think that is our view. But where he can show good cause, then it's reviewable only for plain error.
And how do you think good cause relates to the clear and obvious question under plain error? Like, so you heard the colleague I had with your colleague on the other side, where I said, like, it's black letter law that under Rule 52B, like, I could have never seen this coming, never gets you out of plain error review. Like, you are always, always, always stuck with plain error review, even if you claim you could have never seen this coming. And it would have been frivolous in the circuit I was in at the time, doesn't get you out of Alano, you're still stuck with Alano. Does the government think good cause works the same way? Or can I never could have seen this coming? Or the reason I didn't ask the district court to dismiss the indictment is because the Fourth Circuit had rejected that exact claim. And it would have been legally frivolous for me to ask the defendant to dismiss the government. You see what I'm saying?
Yeah, I think...
Is that good cause? Is it good cause if you can say the reason I didn't raise it before the district court is because I don't ask the district court to do things that are flatly inconsistent with governing Fourth Circuit authority?
I don't think that's good cause
not good
under
cause?
Rule 12 either. No, I don't think that's good cause under Rule 12 either. The purpose of the plain error standard is to encourage litigants to raise their claims even when they believe that their claim may be foreclosed by circuit precedent. But we don't think that's enough to circumvent.
What if it's foreclosed by Supreme Court precedent?
We think even then the defendant should...
It's not good cause to not move to dismiss. So, like, I'm trying to think of an example, like, I don't know, Lawrence versus, I'm just trying to think of an example like Lawrence versus Texas or something like this. The person who never, or heck, before Heller, right? Imagine defendants who didn't move to dismiss their indictment before Heller on the grounds that there was an individual, that person not good cause either?
Not good cause. And that's because, the general assumption is that a defendant should raise any claims in an attempt to preserve them for potential preserved review under a potential change in precedent, right? Heller raised a Second Amendment challenge when his claim, at a time when his claim would have been foreclosed, right? And so there has to be a first, and the point is that defendants should continue to make those claims even when their claims are foreclosed by a consensus of circuit precedent.
Well, you're tracking our case, that Greer versus United States case. You're really tracking that language very nicely there.
Thank you, Your Honor. I read it just recently, so it's fresh in my brain.
Go back to the merits. Is your argument a step one or step two Bruin argument? Do you think this law survives at assume we get to the merits, do you think this law survives at step one or step two?
Assume we get to, so assuming...
You're not waiving anything by answering the question.
Okay, yeah, assuming we get past plain error and assuming this court believes that Bruin and Rahimi abrogated its precedents, we do believe that under step one of Bruin, that individuals with felony convictions are not among the people for purposes of sort of assessing whether they're covered by the text of the Second Amendment.
Has any court accepted the people argument after Rahimi?
Certainly no court of appeals that I'm aware of, and so we would very quickly pivot to...
And because the obvious problem there is that would suggest, because we all agree that people who were convicted of serious crimes who serve their sentences still have Fourth Amendment rights, and so that would require us to read the people as meaning different things in the Second and Fourth Amendments?
Well, we disagree that it's necessarily a different reading. What it is that
serious criminals aren't part of the people. They're presumably not part of the people under the Fourth Amendment either.
Well, we disagree with that because we think that the Second Amendment's reference to the people incorporates the historical understanding of that term for Second Amendment purposes. And so we think that different constitutional provisions sort of incorporate different sort of historical...
Why wouldn't you do that as part of the right to bear arms rather than the people? Just in the same way, for the example that was used, like the First Amendment protects the freedom of speech, which literally read means any law regulating anything anyone says is unconstitutional. But the Supreme Court has sensibly said that when people wrote the Constitution to use the words "the freedom of speech," they did not mean to say that you can commit criminal conspiracy through words. They did not mean to suggest that you can libel a private citizen. Like, even though the words "the freedom of speech" facially would cover libel and criminal conspiracy and criminal solicitation, the freedom of speech referenced in the Constitution incorporates historical limitations. Why couldn't you say the same thing about the Second Amendment, that the right to bear arms in the Second Amendment incorporates these kinds of limitations.
Yeah, we think that the right to bear arms is also a sort of textual hook for imposing limitations on the right of individuals with felony convictions to bear arms. But, you know, the entire analysis is a sort of combined text and history question. I don't think that there's a really clear dividing line between sort of what constitutes the textual inquiry and what constitutes a historical inquiry. Even if you get to the second historical step, we think we've provided sufficient historical analogs to justify Section 922G1 as applied to all individuals with felony
What do you
convictions.
think is the strongest historical analog to the specific crime at issue here? Bracketing whether that's the right way to ask the question, but assuming for the sake of argument that's the right way to ask the question, what do you think is the closest historical analog to this law?
Yeah, I think assuming for the sake of argument only, I think that the historical felony punishment laws that subjected individuals who committed different types of burglary and theft would probably be the closest historical analog. And I appreciate counsel opposite's suggestion that sort of theft or burglary of structures other than dwellings were not severely punished at the founding. I did a little bit of historical research and found at least 2 historical statutes that imposed the penalty of death against an individual who burglarized a structure other than a dwelling, in Connecticut and in New Hampshire. Happy to provide those to the extent this court thinks those historical analogs are necessary to resolve the constitutional question here. We don't think they are. We think this case presents a very easy question under plain error. And this court can follow the framework it set out in Claybrooks to just quickly resolve Mr. Hunt's unpreserved Second Amendment challenge to Section 922G1. If the court has no further questions about the sentencing issue, we'll rest on our briefs on that issue, and I'll give the rest of my time.
Actually, ask you a question, and it may be kind of outside the scope of your job to answer it. So the government really wants courts to just keep doing this on plain error grounds. It seems like, I'm just sort of surprised that you are pushing the plain error point so hard. Wouldn't the government like to get some guidance on the answer to this question sooner rather than later?
Yes, primarily from the Supreme Court. We think that the Supreme Court will, review by the Supreme Court is eventually going to be necessary, but we think that where the issues are unpreserved, the proper way to dispose of those cases is to on plain error review.
Thank you so much.
Thank you, Your Honor.
Mr. Van Stempel, you have some time in rebuttal.
Thank you, Judge. Just a couple things here. So first of all, to respond to your question about the presumptive unlawfulness language, I do believe, again, I guess I would refer back to my prior answer, right?
This is a question about what does the presumptively unlawful language in Heller and Addictive means, and could that language permit a as applied challenge?
Correct, right. And I think the answer is, again, that the fact that Rahimi underscored the fact that courts are required to engage in historical analysis. I think that relying on presumptions aren't enough. I know that some circuits have, right, post-Rahimi, but other circuits, I think, again, I would point to the Diaz case and then also the Sixth Circuit case in Williams, have articulated why they don't feel that that's sufficient. And I would suggest that the same is appropriate here.
Like the phrase presumptively lawful, I guess I would have thought it meant, well, we're just presuming it because the issue's not in front of us right now. Like, we're not actually deciding a case not in front of us, but, you know, when it gets here.
Yes. Yeah, exactly. So it could very well be a shorthand for that issue is not before the court, and so we're not going to touch that right now, right? And I do believe.
Resolve it right now. We're obviously touching it. We
Well,
keep saying,
yes.
yeah.
Yes, yeah, exactly, not resolving it. Yes,
Yeah.
I think that's a better way to put it. So I guess that would be my response to that. Second, in terms of the historical analog, I think this was your question, Judge Heitens. It is interesting because in other cases, so in the Diaz case, for example, in the Fifth Circuit, right there, the court the government did reach out of sort of the set of historical analogs that we've all been talking about in this case, which is the same as what we've been talking about in Rahimi, right? So there in Diaz, they reached out and they said, well, look, there's this other statute in the colonial era that penalized horse theft. It was a capital crime apparently back then. And so they analogized from that horse theft to vehicle theft, so therefore the defendant there lost the as-applied challenge. Again, here, I mean, to the extent that the government has additional research, I haven't seen that. But again, I would suggest that that's different than what's happened here in the briefs, that the government has not reached outside of the historical sources that were already reviewed in the Rahimi case. And so I haven't seen any historical analog.
So
to
while
your
you
point.
have a few minutes left, can I just ask you to respond, broadly speaking, to the Eighth Circuit's reasoning? So I'll summarize very briefly at a high level of generality. What I understand the Eighth Circuit to have said is the relevant historical tradition is that government can disarm people who have been adjudicated guilty of serious crimes. That's the historical tradition. And then the court says, if you're looking for a justification for that tradition, there's maybe two different theories of justification. One I'll call sort of forfeiture and one I'll sort of call dangerousness. But what the Eighth Circuit said is the relevant tradition is the government can disarm people convicted of serious crimes. Why is that wrong?
Well, I think it depends on what is meant by serious, right? Because I think
What the legislature decides is a serious crime. Because like one of the sort of fundamental principles you learn in first-year criminal law is the legislature decides what's a crime, right? Courts don't decide what's a crime. The legislature decides what's a crime.
yeah, so exactly. So the problem is that if you run that analysis far enough down, then you get to the problem where the legislature can just decide that certain conduct is an offense, and then they decide it's serious by putting a 1-year penalty on it. That means it's a felony, and if it's a felony, then suddenly it's serious, and suddenly it's outside the
Yeah,
scope
the
of the
power to
Second Amendment.
criminalize things is quite a power, right? You can send people to jail. I mean, you can do all kinds of things to people once you decide something's a crime.
That's correct. So the legislature can decide what a crime is, but the legislature can't decide what's a crime and thereby limit the constitutional right, because that's what it would be,
But
right?
why not if there's a historical tradition of disarming people who are convicted of crimes that are deemed serious?
Well, because I think it,
Under Bruin, that's literally all we look at. Like, it's kind of weird, right? Because if we were doing, traditional rights analysis, we would ask, well, is this narrowly tailored to say all felons without inquiring as to an individual, or there'd be narrow tailoring, there'd be means and fit, but we don't do that anymore. We just say if back in the day they thought they could disarm anyone who committed a serious crime, we're good.
well, and again, I think the Diaz case from the Fifth Circuit talks about this, where that approach at the end of the day leads to an approach where the legislature can regulate the Second Amendment way. And I think Justice Barrett's,
Up with Bruin, I mean, that's what Heller and Bruin tell us to do.
well, I think Justice Barrett's concurrence in Rahimi actually talks about this, right? She talks about the level of generality, of course. And that's, of course, the issue after Rahimi. The question is, is it really general or is it more granular? And I think Justice Barrett articulates, if it's too high of level of generality, then you essentially regulate the constitutional right away. And I think that's not the way that constitutional rights work, certainly not in any other context.
Thank you, Mr. Van Stumford. And the court notes that you have been court appointed for this case, and I will commend you on behalf of the panel. I think that you've done an excellent job. You're just the kind of lawyer that we like to have in this court for these kinds of cases, and without services from lawyers like you, it'd be very difficult to do these cases. And Ms. Reed, I will say to you too, you're just the kind of lawyer we like to see to come from the U.S. Attorney's Office up here. So very good arguments today, and the court will now come down and greet counsel and proceed
Thank you, Your Honor.
to the next case. Okay? The next case. All right, we'll proceed to the next case. You may be seated, please. By the way, I'm going to recognize the presence of the students from DMI and their professors here. the port of the military bearing I'm seeing here is really nice, gentlemen and ladies. It's to see you stand up and remain standing until told to sit down. That tells me you're getting orders very nicely. One who spent quite a bit of time in the United States Navy. I appreciate that and appreciate your presence here today. We proceed to the third case, which is Liberty Mutual versus Attain. We will hear from the appellate's counsel.
May it please the court. Good morning, Your Honors. My name is Marcy Scow. I represent the appellant, Attain Specialty Insurance Company. Liberty Mutual brought this claim against Attain, seeking to enforce an indemnity right to recoup $1 million that was paid on an appeal bond that was purchased by Attain on behalf of its insured.
Let me just ask something just curious to me about this appeal bond. You have a case, Attain is involved in it, and it proceeds through the process. They lose almost $1 million there. Goes up on appeal. Attain gets an appeal bond from this big old company called Liberty, which is like number 2 in the nation. We're giving these out to sustain during the appeal. Process goes along. Someone comes along and says, okay, you're not liable for these to pay as an insurance company. And then somewhere between the two groups of people here, between your company and Liberty, it gets mixed up as to whether this bond is closed. Can you close that bond?
Your Honor, technically speaking, the bond says it will become void if the judgment's paid or the underlying judgment is voided on
I'm trying to
appeal.
figure out the purpose of a bond. The reason the court is allowing this appeal to go forward is somebody has put up a bond to tell this plaintiff, okay, we're gonna not pay right now because you're gonna get paid if you win. How do you close that bond?
Yeah, so the purpose of an appeal bond is to stay enforcement. It's to ensure the plaintiff is going to get paid.
That's right.
What Liberty's counsel recognized, when asked about this in
Now,
her...
my question is, how can you get rid of that bond? I don't care if you're liable or not. You have a bond. This is the bond you put up there. You said, we will pay.
Right.
And how do you get rid of it?
So claim counsel for Liberty acknowledged that one of the ways you can get rid of the bond is, quote, a court order discharging the bond for whatever reason.
That did not happen.
It did not.
So you didn't go to court and get it. So what's the other way?
Well, the other ways are payment or the judgment being overturned. But I want
Didn't
to,
do that either.
those two things didn't happen either.
So
Correct.
how can you get, even if everything you say happened here, at the end of the day, that bond is still there.
Right.
That bond is going to be paid. You were the one that went and got it. So how do you get out of it?
Yep.
I'm really I get your point in terms of the back and forth. They told you they closed it the whole bit. And this business that they're the big company and you're the little company. There's no such thing here. All these are big companies. And I am miffed that anybody, I don't know who your lawyers were, that would think that you can close a appeal bond by some agents and some claim directors going back and forth with their communication as a court. So you either got to go to court and get it, or you got to pay it.
Right. So, Your Honor, your question, I think, goes directly to the issue is how is Attain prejudiced by any of this if they couldn't just go get it closed?
That's a good way of putting it.
And so to answer that question, Attain could have gone, so Liberty's counsel said, well, you go get a court order discharging it. And so Attain could have gone to the trial court. It didn't. I fully recognize it didn't.
And just the trial, it's confusing to you, there's like 3 courts here, right? There's the state trial court where the underlying action is happening. There's the coverage action, and then there's the action that we're hearing now.
Right.
So when you say that you could have gone to the court, you mean, I just want to make sure I understand. So what we hypothesize could have and perhaps should have happened is that someone should have gone to the state trial court and said, hi, we're Liberty, we put up this bond. We did that because at the time we thought Attain might be liable to provide a defense in this case. Turns out they're not. Here's this court order and a coverage action. Please let Attain and Liberty out of the bond, at which point presumably the state trial court would have said to the defendants, so it appears that you don't have an appeal bond anymore, and unless you get a new appeal bond pronto, I'm going to dismiss your appeal because you don't have an appeal. Is that procedurally what should have happened?
Yeah, procedurally, whether it would be Liberty or Attain going
Someone.
and seek, yeah.
Right.
They would seek that relief. state trial court judge, look, there's no more coverage, we shouldn't have to pay on this bond anymore.
And nobody knew this?
Attain had had 3 appeal bonds in a decade. This was the first appeal bond ever handled by.
She's got a lesson to learn from this case.
I think you're correct about that, Your Honor. Absolutely.
I mean, intuitively, think about it. It's essentially, you take $1 million and you hand it to the appeal court, forget the bond, and says, here's $1 million. You get to be paid if you win. You then have negotiations in terms of, well, I'm not even liable for not the appeal bond, I'm not liable on coverage. And he says, okay, we're gonna cancel that, but you didn't go pick up the money. Isn't that kind of what it is? You did not go and get your money back, you left it right there.
That is-
Not only do they want the appeal bond money back, they want the premiums of $2,800 back on top of it.
Right, and so you're right, they did leave it there. And if they had gone to the state trial court and asked, the state trial court may well have said, yes, I'll allow you to remove that bond. Insureds, you go get a new bond in its place. The state trial court could well have said that. The state trial court could also have said, no, that appeal bond is staying in place. And if the appeal bond stayed in place, and if Attain knew the appeal bond was staying in place, then it could have taken other steps to minimize its loss.
Like what?
It could have taken its coverage action, coupled with the arguments on the appeal merits in the state court case, and gone to the plaintiffs and tried to negotiate a settlement for something less than $1 million. That would have mitigated its loss.
Question, so this is really interesting to me. I was trying to figure out what should happen in this case. But I'm not gonna find any of this discussion in the record of this case. Your corporate designee burdens on Attain, and as you say, this goes to prejudice, and they ask him, what would you have done if you had known? He's like, I don't know, like a court order maybe?
Right, so what
But
Attain...
basically, he says, I don't know.
What Attain said in the record, they were asked, what would you have done? And they said, we don't really know. We would have asked more questions. We would have expected direction. If Mr. Dunnigan had come back and said, hey, Liberty's not closing this bond, you're still on the hook, their next question would have been, okay, what do we do? Give us some direction. And they would have kept going down that path.
Don't you have lawyers?
Yes?
I mean, so you go to your lawyer and says, what do we do?
Well,
It's called malpractice if you don't do something like this. That sounds like to me.
Well, keep in mind that the defense counsel who's representing the insureds in the state court case is representing the insureds. Attain is paying their defense costs under
I
due
understand
defense.
exactly how you did it. You took on something you probably didn't have to do here, but you did it, and you paid for an appeal bond. You put $1 million up there on the table, and then you had this little discussion about, well, we're gonna close out the bond, but you never picked up the $1 million.
Right.
And the plaintiff did. And so now you're saying the plaintiff picked up the $1 million. We ought to be, at least Liberty ought to be equitably stopped from collecting that $1 million from us because they knew better, but we didn't.
And that is true, Your Honor. They knew.
It's true you didn't know better.
We did not. We were not, Attain was not experienced with these bonds.
Like, we can't have like, an estoppel jurisprudence that turns on like weighing the relative merits of two different in-house legal departments. Oh, these guys seem really smart, these guys not so much. Like, that can't be a basis for equitable estoppel.
Right, and Your Honor, I think here the idea is that Liberty, by not collecting premiums, by telling the agent that the bond was closed, it, sitting in that expert position, told Attain that it was, that the bond was taken care of.
I have
Well,
questions.
procedurally, it was closed. They stopped collecting the premium.
Right,
The problem is the bond is, the $1 million, so to speak, is still there on appeal.
right.
That's the problem.
Yeah, and I think it has to be viewed in context, right? The indemnity agreement says premiums will continue to be charged until Liberty is provided documentation that satisfactory to Liberty of its discharge or release of all liability on the bonds.
That wasn't given.
Well, Liberty thought it was because Liberty closed it down.
But there was no documentation that anything has been settled. Basically, you're talking about that, you're talking about the case on appeal. You need to provide documentation, that case is over, not the coverage case. Two different things. You know what? Attain was smart enough to go to the federal court for coverage, and knowing they got a case in state court, that's pretty savvy. to know that you can go there and get coverage determination separate from this, but they don't know they got a separate case over there in state court that has $1 million sitting on the table that they have guaranteed that they're going to pay?
Yeah.
They don't know that?
They did not understand that, no, they did not. And so when Liberty stops collecting premiums, it's because Liberty has been satisfied that the document shows there's no remaining liability on the bonds.
Again, it's not, your corporate designee didn't say, I relied on that, and they stopped charging premiums, I figured you were off the hook. He says, the only thing I looked at was these emails from Liberty to our broker.
And, Your Honor, I know that that is what Liberty has said in their briefing, and they refer to page 91 of Mr. Dittmar's deposition, which is at the Joint Appendix 235. And that is what he says. You know, are there any other things that you relied on other than the email? And he says, not that I'm aware of at this time. And then if we flip over 5, 6, 7 pages in his deposition to JA 239, he's asked the question a little differently. He's asked, what actions are you referring to where there's a longer interrogatory response that's being read about Liberty misleading Attain. And counsel asks, what actions are you referring to there? What actions by Liberty, in essence, misled you? Well, included, it says right there was no further invoice for the premium on the bond from Liberty Mutual and the December 19th email.
But that's about misleading you, not about what your reliance on the misleading statement is. Those are two, you agree for estoppel, those are two separate requirements. They have to mislead you and you have to rely. And I take your point that I see how that goes to misleading you. How does that go to reliance?
They relied on that, I think it's a few pages later.
Well, not just reliance in the ether, right? As I understand estoppel, you have to rely to your detriment. You have to do or forego something, and that doing or foregoing that something was to your detriment. Where does he say that there's something we did or didn't do to our detriment?
Yeah, I don't know that the testimony is, if we had known the bond wasn't released, we would have asked more questions and taken more steps. We know that Mr. Dunnigan.
Is the burden of the party that has to show estoppel to identify something a little more definitive than we would have done something?
Well, we would have asked questions. I'm not the expert here. I don't know what I would have done. I would have asked questions of the experts to figure out what the next steps were.
But this deposition is being taken as part of this lawsuit. Presumably by that point, Attain should have been able to figure out what they would have done differently.
Well, and I think their agent, Mr. Dunnigan, said if he knew it hadn't been closed, he would have told Attain to go get a release. Liberty's claim counsel says somebody should go get a release. That's what they would have done, but nobody told them they needed to, and so they didn't do that. And they're prejudiced because they didn't do that. They didn't get a yes or no answer. Again, the no answer to the state trial court telling them, no, I'm not going to release this bond. I don't care that you have this coverage determination.
But it's not Liberty's action. It's Attain's action. They are the ones who ultimately could be liable for this. If they are no longer liable for it and they put a bond on it, they are the ones that ought to go and represent. I'm not liable. Liberty is not liable on this at all. What they have is an indemnity. We are doing this for you because you are liable on it. So why would they have to go to the court and say, okay, are they liable anymore?
Yeah,
Because they got a bond. And you said this is what you contracted to get.
and I'm not suggesting the burden was on Liberty to go take those actions. What I'm saying is when Liberty said the bond was closed down, Attain had started, remember what started this all is Attain gets the premium renewal.
They couldn't close it down.
But it could have gone to the trial court and asked, and the trial court could have said yes or no.
Well, that's the same thing. As you're saying, they had to go to the trial court and say, Attain is no longer liable for this. But Attain is the one should have gone and told the trial court, we're not liable, didn't tell them.
Right, and when I say they, let me clarify. When I say they, Attain could have gone to the state trial court and said, court, release this bond.
True.
And the court could have said, yes, great, I'll release you, insureds get a bond in its place.
But Attain did none of that.
It didn't. The trial court also could have said no. And if the trial court said no, Attain then could have taken other steps to try to minimize its loss, negotiating a settlement or with the underlying plaintiffs.
Well, if you got $1 million on the table, you got a jury verdict, and you feel like you got a strong case, not a whole lot of negotiating you're going to have that happen there.
Perhaps not.
You could have negotiated a settlement even before before the coverage. You could have been doing that. There was no attempt to negotiate a settlement.
Right.
You were appealing this thing all the way to the Supreme Court. And, you know, settlements are negotiated when the jury comes back with a verdict of 900-something million. That's when you come out and says, well, we can appeal it or we can settle something. There's a Senate to do those things. Not when it's already sitting up in the Supreme Court and been sitting there with $1 million bond up there securing it. Pretty good facts, too, to substantiate it, by the way, and a jury verdict. And I don't know what the legal arguments were. Maybe you could have negotiated and got it down some, but I don't know what it would have been.
Yeah. Your Honor, can I tell you one other way they could have minimized the
Yes,
risk?
tell another one.
The other way they could have minimized the risk was trying to renegotiate the deal with Liberty. Having Liberty look to the security of the insureds. The insureds owned a hotel property. It's not as though they were assetless.
Doesn't Attain have a right to pursue that against McClure?
No,
Because they are no longer, so the fact that they don't offer coverage, but they in fact pay, they have no cause of action against McClure. I'm asking.
and I'm hesitant to answer, and this is why. I'm a Texas lawyer by nature. I do not know what West Virginia coverage law would be on that. And so I'm hesitant to give an answer that's incorrect. I would tell you that in my experience under Texas law, absolutely not. The insurance company would never be able to.
West Virginia, Texas and West Virginia, two different places. I'm not saying
Yeah.
there's coverage.
Yeah.
But I'm just saying, you know, it seems like to me that's relevant when you start
Yeah.
saying
And so,
Liberty could have mitigated this damage. But I would think with McClure, why wouldn't Attain be the one that's trying to do that?
right, and it could have been negotiated. And to answer your question, I don't know under West Virginia law. I can't answer that question, and so I don't want to give you inaccurate information. I'd rather give you no information than inaccurate information on that question.
We'll give you some time in the book.
Thank you.
How's that? We'll hear from you, Ms. Lee. All right, give it to us. Why is it that Liberty, as I understand, the second largest surety company in America, would have this kind of a situation develop where someone tells them there's no coverage or we're not liable, and they said we closed the bond, and don't at least have the savvy to say, well, where's the documentation? I mean, what did you close? Did you pay it, or did the court do anything? I mean, it's sort of mind-boggling. I mean, I gave a hard time to the other side, but it's true in terms of Liberty. You got lawyers, don't you?
Well, Your Honor, very good point. I think the facts show that really it was a representation by Attain is what caused Liberty to internally document the closed bond event. So it really, Liberty was relying upon the documentation that Attain provided, saying this is in fact documentation that has been won, that the case has been won or closed, or the bond liability has been extinguished. I mean,
The documentation was of the declaratory judgment relief.
correct, Your Honor.
Why would Liberty think that could possibly extinguish this bond?
I don't believe that Liberty did believe that that could possibly extinguish this bond.
They not look at the attached documentation, is that what you're saying? Because Attain sent something and they said attached to this is something that will show, and then so they didn't look at what was attached.
I believe the testimony at the lower court or at the trial court level in the deposition was that they believed that because it was represented that this documentation was sufficient to show that the case had been won and closed, or the bond liability had been extinguished, that they believed that was in fact the correct documentation. I believe that is.
Unusual, but okay.
Well, and I don't know that that is kind of, well, first off, may it please the court, my name is Melissa Lee. I represent Liberty Mutual Insurance Company. I do want to, I think Attain has taken the facts of this case. They've put them into a bag, and they've taken some out, they've put some in, they've kind of shaken them up and presented them to the appellate court to say, there's a disputed issue of fact. I think Your Honors have been very diligent in noting that some of the facts that have been presented are a little bit mischaracterized, and I want to go through that and clarify some of those mischaracterizations.
But even with the facts as characterized, whatever, this is some messy stuff on both sides of this in terms of the insurance company, Liberty and Attain here. I I mean, the questions we just posited to you then, is you got Liberty up there. They're the ones with the bond. What is it that they receive and say, to the extent that they would say bond is closed? Well, bond closed doesn't mean you won't have to pay that bond. I mean, not getting premiums doesn't mean that that the bond is dissolved. That's a court thing. And seems to me, you have to have a lot of hope that, so like the McClure, maybe whatever, that a team can actually pay you on this, for you to say, okay, bond closed, to just walk away and say, that's the end of it, without doing one of those two things that probably everybody would think, that if you got a bond, you put $1 million up, you go to the court, and says, court, release me from the bond, or you pay it. So neither one of those happened. So, I mean, so it goes back and forth, is the reason we're saying, maybe mischaracterization of facts, but even with the facts clear, it's still messy.
I think this is actually a very straightforward case. It's a breach of contract case. And I think the undisputed evidence at the trial court level show the judgment was, should have been entered and was entered in favor of Liberty. And in terms of the bond's closure, that is an internal billing event, and that is an undisputed fact. Liberty clicks a button that says the bond is closed. What that means is that they no longer charge a premium on the bond. That button can be unclicked, and that has absolutely no impact on the legality of the bond and Liberty's obligations under that bond. And more importantly, this case is not about the bond, it's about the indemnity agreement and how that bond's closure somehow impacts the obligations of Attain under the indemnity agreement. I don't see that.
Well, the only reason it comes up because of this doctrine called equitable estoppel.
Well,
All of what you say, they acknowledge that's true, but they said, that's true, but you shouldn't be allowed to do it because of da-da-da. That's the only, that makes it a little less straightforward on it. But it doesn't mean that you don't prevail on it. It's just, that's their perspective on it. They acknowledge what you just said. All of that is true, but they say you should be equitably stopped from doing it because, from their perspective, you represented it was closed and they thought it was closed.
Well, I believe the liability of Attain is derived from the indemnity agreement, not from the bond. And the indemnity agreement does not have a provision whereby they can simply terminate their liability and say, oh, the bond is closed, therefore we're no longer obligated. And so I think you have to go back and look at the indemnity agreement and the terms that it has and the obligations that Attain has under the indemnity agreement and the rights that Liberty has under the indemnity agreement in order to fully assess Attain's liability.
To me, if someone stopped paying you premiums and you agreed to it, that kind of indicates this thing is over. There's no indemnity agreement anymore. It's kind of gone because that's kind of what insurance companies do. You don't pay their premiums, you don't get to cash it in.
I don't believe so, Your Honor. I believe if you look at the language of the indemnity agreement, if you look at the language of the bond itself, it is very clear that the liability under the bond is not extinguished.
I agree that's what the liability, I agree that's what the bond says. I guess this whole thing strikes me sort of as a comedy of errors and lots of people saying lots of things that strike me as obviously wrong, right? I'm just going to posit as a starting point. It seems to me there simply had to be some way for Attain to get out of this bond after they won the coverage action. And that I am going to find unpersuasive any argument that is premised on the fact that there was literally no way for them to get out of it. Do I have to think there was literally no way for them to get out of it in order to rule for you?
Your Honor, I don't believe so, but I don't.
Okay, so how could they have got, great. Walk me through, this is not the world we live in. I think we can all agree what happened here is not ideal on any level. What should, if Attain wanted to get out of this agreement, they should have done both. Well, if they wanted to get out of the obligation to pay this money after they won their coverage action, Attain should have done what?
They should have paid the underlying claimants, which is what Liberty asked them to do initially. They should have paid the judgment.
They won their coverage action. The whole point of winning the coverage action is this is not our responsibility. That's the whole point of a coverage action.
That is the case, but that doesn't extinguish their obligations under the indemnity agreement or Liberty's obligations under the bond. So, and you're right, to some extent, this is a comedy of errors, but not on the part of Liberty.
No, you're not going to go. I don't understand how when the Liberty employee tells Attain the bond is closed. I know you have an argument that that means something uniquely internal to Liberty. I find that facially implausible. When someone tells me the bond is closed, I, as a reasonable person, understand, no, it's closed, like the way normal human beings would use the word closed. So I don't think you can say there's no errors on the part of Liberty here either.
Your Honor, I believe the record reflects that Liberty never told Attain that the
I don't
bond
care who
was
they told.
closed.
They told a person the district court said was Attain's agent, and telling someone's agent something is the equivalent of telling that person something.
I don't believe that it is established that Mr. Dunnigan is the agent of Attain.
But the whole rationale of the district court depends on the notion that Mr. Dunnigan was the agent of Attain, because once the district court concludes Dunnigan is Attain's agent, that's how the court is then able to say Liberty didn't say anything, because they rely only on a Dunnigan to Attain email, and the court says, well, that can't be a misrepresentation by Liberty, because Dunnigan was Attain's agent, and you can't make a misrepresentation to yourself.
Your Honor, I believe that the district court looked at this factually as a whole and looked at the elements of equitable estoppel.
No, the district court, I think the district court pretty clearly said there was no misrepresentation by Liberty to Attain.
And that is factually correct, Your Honor. There is no...
Only if you don't realize that only if you assume that a misrepresentation to Liberty's agent is not also a misrepresentation to Attain's agent is not also if someone misrepresents something to one of my law clerks, that is legally a misrepresentation to me, right? If I ask my law clerk to call a lawyer or someone about something, and that person represents something to my law clerk who is acting as my law clerk, that constitutes legally a misrepresentation to me, right?
And that is a different relationship than the relationship at issue here. I mean, this is simply serving as an intermediary does not make you an agent. It's kind of like a game of telephone, right? You're going from one party to the other party. Simply because information is passed through an intermediary does not mean that that intermediary assumes the role of agent to either party. And here, I mean, one thing within the record, the bond was signed by Mr. Dunnigan on behalf of Liberty. I think and that is found in the joint appendix at 32 and 33. So I don't believe
that doesn't really help you, because if Dunnigan is Liberty's agent, then any misrepresentation by Dunnigan to Attain is a misrepresentation by Liberty to Attain.
I don't believe that Mr. Dunnigan served as an agent of Liberty.
You said he signed the bond on behalf of Liberty. That sounds like acting as an agent of Liberty to me.
Well, I don't believe within the context
Do non-agents get to sign legal documents for people?
Well, Your Honor, they're limited to the scope of the agency.
Fair.
And I don't believe the conversations are...
Even if you assume all this for argument, your argument is still the same. I mean, in terms of the indemnity agreement and its effect on this case, it's very clear that Attain did ask this agent broker, Dunnigan, to get that bond. He's the one that got it for him. And so there's some plausible indicate he's the agent of it. I think it all comes down to when you think of a case like this, and when you're dealing with trials, you wonder, well, how can we fix this in the future? And one of the first questions that come to you is, why didn't you get coverage determination earlier, Attain, in terms of whether you do it? Because every time it was McClure. They're the one, McClure had the judgment against them. And it was McClure that asked the court to stay the paying of it. And it was McClure that said, that the court says, okay, you can stay it, but you got to post $1 million bond. That's McClure. Attain jumps in this thing and says, they said, okay, would you do this? And they did it. They did it with you. Totally different questions of what happens after, but essentially Liberty then gets this $1 million bond. I analogize it probably incorrectly to say you put $1 million up there on the table. And then the question is, how do you get that $1 million off the table? You don't get it by those little underlying conversations. You get it by one of two means. You either go up and you figure with the court to say you don't need it anymore, or you pay it, or you negotiate. You do something else, but you can't just do it here because you got a court involved. When courts get involved, and the reason the court says it wouldn't stay this action unless you put $1 million bond up. And I don't know where in the world anybody gets the notion that $1 million bond is going to disappear because the people that got the bond got together and says, okay, it doesn't exist anymore. Seems to me you're not including the court in the process either. Even if you paid it, you probably have to go tell the court that you paid it. Something has to be done with the court that you put that $1 million bond in. And that kind of seems to be the direction we're going here, even though you turn it on and very straightforward. You say it's not a comedy of errors. I'm going to Judge Hayden. This is a comedy of errors here in terms of facts. But I don't know if the outcome, that determines the outcome. A lot of times we get cases with comedy of errors in it. I'm hoping somebody's learning some lessons from this. Liberty or Attain or somebody, these big time insurance companies, you gotta be kidding me that we're looking at this case right here. No one knew what to do here, and we read those facts, and it did look like a comedy of errors. This is, who in the world are these people here? And they're big time, multi-million-dollar, billion-dollar insurance companies and stuff that are doing this stuff here. And so that's kind of the posture you're in today. But I mean, your argument is pretty straightforward, at least, and I commend you sticking with the law, and the law is getting on that indemnity contract, which is the basis upon which we're here today.
Can I ask you a question about your position that I'm not 1,000% clear on? And it sort of goes to this question of who's an agent for whom. And I understand you cited a bunch of New York cases saying whether or not Dunnigan, whether or not someone misrepresented something to someone, in order to have, there may have been a misrepresentation from Liberty to Attain, but Attain has to have actual knowledge in order to be able to claim that it lied. And I thought part of your argument was whatever got said by Liberty to Dunnigan was never transmitted to was never transmitted to Attain. And so they couldn't actually have relied on it because Dunnigan never turned around and told Attain, good news, the bond has been closed. And there's all these cases you cited from New York saying if you find out about communications only in discovery during the lawsuit, you can't turn around and say, well, that's what I relied on at the time. So I'm just trying to understand, if Dunnigan had forwarded these emails that he got from Liberty saying the thing is closed, had Mr. Dunnigan forwarded those to whoever this corporate designee person is over at Attain, would the fact that it went through Dunnigan foreclose a reliance argument? Do you see what I'm saying?
Yes, Your Honor. I believe here the facts show that Attain never had actual knowledge of closure of the bond.
And if they had it come from Dunnigan, an intermediary, and not from Liberty, would it still be a different case? Because they would have the actual knowledge, even though it didn't come straight from Liberty?
I believe that would certainly change the case.
Okay.
I don't believe that it would change the ultimate outcome.
So your argument is not that it doesn't matter what Dunnigan told Attain, because he's not their agent. Your argument, at least as it goes to actual reliance, is he didn't actually tell them anything.
Correct, Your Honor. There was no actual knowledge.
Clear up, yeah.
They've admitted they didn't have construction, or they're not arguing that there was constructive knowledge. So therefore, they have no knowledge of this. And if they have no knowledge, how could they possibly reasonably rely on something of which they have no knowledge?
Can we go back? So it's JA 501 and 500 to 501. To me, on JA 500 to 501, the district court very clearly assumed that Dunnigan is Attain's agent for purposes of its analysis. It says that Attain does not deny that Dunnigan is his agent, and the district court then leverages that to say that because they don't deny Dunnigan as their agent, no statement by Dunnigan can be the misleading statement because you can't mislead yourself, okay? So I read the district court's opinion as premised on the assumption that Dunnigan is Liberty's agent. If we have to premise that Dunnigan is Liberty's agent, who cares if Dunnigan told anybody else at Attain? That's like knowledge of an agent is imputed to the principal, right? That's black letter law. You impute the knowledge of an agent to the principal.
The step
I could
is,
cite a whole bunch of New York cases that say you impute the knowledge of an agent to a principal.
the step is the reasonable reliance.
I agree, but for purposes of knowledge, we impute the knowledge of the agent to the principal.
I understand what you're saying. The point we are
You
making.
deny that that's black letter law.
I'm not denying the law. I'm saying that the point that we are making is that without that knowledge, there cannot be the next step of reasonable reliance.
So what if Dunnigan relied? What if Dunnigan, I mean, now I take the whole point about the record, but what if Dunnigan is deposed and says, well, the reason I didn't take any further steps, acting with my hat on as Attain's agent, is because I thought we were good to go, because Liberty told me we were good to go. And if you had not told me we were good to go, I would have investigated. And, like, so what if Dunnigan said those things? Wouldn't that, why would it matter whether Dunnigan told anybody at Attain, anybody else at Attain? Because if he's their agent, he is Attain.
Because to your point, Your Honor, this is not in the record.
Totally agree about that.
This is not in the record, and
What I guess I'm saying is, it seems to me that whether Dunnigan told any other person at Attain is sort of a red herring if he's their agent.
Your Honor, the entire defense of Attain has evolved over time.
Fair,
And
totally.
and this latest iteration of it is this idea that of equitable estoppel through an email from Liberty to Mr. Dunnigan. It is undisputed that never was received in any form or fashion by Attain. So therefore, again, we can't demonstrate reasonable reliance. And again, going back to the point, there wasn't a misrepresentation in that as well. I mean, closure of a bond is an internal billing event that triggers something where premium is not charged. And that has no impact on the legal obligations of Liberty under the bond. I want to conclude on one idea. So it's important to remember that equitable estoppel is a doctrine of equity that, put simply, should operate in such a manner that makes the circumstances fair. There's a case that was cited by the district court, Cooper Kraus Hines. It says estoppel is imposed by law in the interest of fairness to prevent the enforcement of rights which would work fraud or injustice upon the person against whom enforcement is sought, and who, in justifiable reliance upon the opposing party's words or conduct, has been misled into acting upon the belief that such enforcement would not be sought. I think we are missing a number of elements here within that. And then I want you to think about the equities of Attain's argument. They sign a contract, the terms of which remain enforceable. Liberty issues a bond on behalf of Attain's insureds in reliance upon that contract and the promises that were made therein. Attain provides incorrect documents to Mr. Dunnigan for delivery to Liberty, saying that, close the bond, premium should not be charged. The closure of the bond is a billing event that doesn't impact obligations under the indemnity agreement or obligations under the bond. When Liberty must pay out on the bond, it looks to Attain to fulfill its obligations under the indemnity agreement. Attain refuses to honor those obligations because of its own mistake, not Liberty's mistakes. And if your honors have no further questions, then I will rest on my brief.
Thank you for your argument. Ms. Shout, you have a few more moments in rebuttal.
Your Honors, I want to start with this idea that a misrepresentation about the bond can't impact the obligations under the indemnity agreement. The bond and the indemnity agreement are tied hand in hand. The indemnity agreement indemnifies amounts that will be paid under the bond. If Liberty represents, hey, that bond's been taken care of, it's closed, that's representing to Attain that no amounts are going to be owed under the indemnity agreement.
Did Liberty conceal any facts or misrepresent the status of the bond?
Yes, I think they did misrepresent the status of the bond.
When they said it was closed.
When they said it was closed and when they stopped charging premiums. Remember, under
Because
the
insurance companies generally don't provide you coverage without you paying for them.
insurance companies have that pesky habit, that's correct. And
Well, it said, we will close this bond and gives a number in our system. That does not extinguish the obligation of the bond.
it then went on in another email to say, the first email said, we will close the bond in our system. The second email said, this bond has been canceled. I have backed out the 2020 renewal premium that we charged. That's important because remember, back in the indemnity agreement where it talks about premiums, Liberty says we're going to charge premiums until you provide documents that satisfy us that the bond has been satisfied. And so when Liberty says we're not charging the premium anymore, Liberty is in essence, under this provision in the general indemnity agreement, saying we've been satisfied that we're never going to have to pay anything on that bond. That's how that comes full circle.
So you had mentioned you've been to Texas and West Virginia, but which state law would be the basis for looking at this indemnity contract?
The indemnity contract has a choice of law provision that provides that New York law will apply to the enforcement.
Look at New York law in terms of how we interpret that contract.
The indemnity contract, yes, it's governed by New York law in this case. Yes, yes. The other issue is this, how this representation was transmitted to Attain. And again, I think it's important to look at the context. Mr. Dunnigan was Attain's agent. It was, Liberty knew when it was talking to Mr. Dunnigan, it expected and intended. The testimony from Liberty's folks is they expected and intended when they talked to Mr. Dunnigan that information was going to be passed on. And the information was passed on here in the form of not charging premiums. And if you look at the email communication with Mr. Dunnigan, when he's communicating with Attain, he says, I will go work on closing this bond. We will go.
I'm sorry, finish your sentence.
We will go work on closing this bond. Should there be anything else we need from your end, we will be in touch. And then Mr. Dunnigan doesn't get in touch further because he's been told the bond's been closed. That communicates to Attain that the bond has been closed. And so that representation was absolutely transmitted to Attain, and Attain relied on it in not taking further steps to keep going down this path of what do we need to do to deal with this bond.
Although, again, your corporate designee doesn't say he relied on that.
In his testimony, he talks about the actions that were taken that misled him, or the not charging the premium and this December 19
When
email.
asked, what did you rely on? He points to something different, but that's, okay, that's, my question was, how much are you relying on would your argument be the same if there were no chit-chat, no back and forth between these various people, but just suddenly they stopped charging premiums? Is that enough? At that point, Attain could be like, great, for reasons unclear to us, we are off.
I think if there was just the premiums stopped out of the blue, I don't think that has the same import. I think here you have to look at all the facts and context. They got a renewal premium. And
What about if they didn't cancel the renewal? There's still, I'm just trying to figure out what weight to put on the various facts. So now imagine they continue to bill, but there's this email exchange that does or doesn't make its way to Attain.
Yeah, if they continued to bill premium, I think that's a representation and conduct from Liberty Mutual that would factor in and show that Liberty didn't consider this bond released. I think that would be a different fact.
Do I look at, as I'm going to get my chronology wrong, but after all of this happens, the McClure's lawyer emails Attain and says, please continue funding the defense because there's an oral argument, and he says there is an appeal bond in place written by Liberty Mutual Insurance Company. Do I factor that in when I look at all the facts that Attain is actually being told, hey, there is a bond in place?
Yeah, and I don't put much weight on that fact. It's coming from defense counsel who was not privy to any of the conversations that have been going on about the bond itself and about the cancellation of the bond.
Presumably, like he says, it's in place. He may be the one lawyer in all of this who checked with the state court and like, yeah, there's a bond in place.
Yeah, and I hear that. I think, though, the fact that he's defense counsel and he's not been involved in any of the discussions tempers why, that explains why Attain doesn't do anything in reliance or in reaction to that.
All right, well, thank you very much for your argument. Thank both counsel. We'll come down and greet you.
I'm happy to do whatever you want.
We'll proceed to the next case after we greet counsel. You may be seated. Final case for today we'll hear will be the United States versus Jennings, and we'll hear from Defenders Counsel.
Thank you, Your Honors. May it please the Court, I'm Ann Hayes. I represent the appellant Raymond Jennings in this action. I plan this morning to focus my argument on the speedy trial claim that's presented in argument 1 of my brief. Of course, if the Court has questions about other issues, I'd be happy to address those. There's no dispute on appeal that Mr. Jennings was entitled to dismissal of his first case due to a speedy trial violation. The district court erred, however, when it dismissed the first case without prejudice rather than with prejudice. The district court's decision rested largely on 2 clear errors of fact. And those,
Judge Osteen's decision you're talking about.
That's correct, Your Honor. And it's important to note that Judge Osteen made a decision based on things that happened in a courtroom over which Judge Biggs was presiding and where she made findings that were inconsistent with the findings that Judge Osteen later relied on.
Just about got everybody in the middle district, didn't you? You got
Just
this
about.
strong case.
Just about, Your Honor. In fact, a 3rd judge presided after the ultimate trial.
Okay, but just to tee up the issues then, since you brought that up, I mean, we have cases about when, under what circumstances, the district court can reconsider its own previous findings or order, and in particular, how that's impacted if it goes from Judge 1 to Judge 2. I don't understand any of your argument to depend on that. I mean, I know it may be atmospherically helpful for you, but that's not the argument you're making, right? That Judge 2 committed some sort of procedural error by disagreeing with Judge 1.
I think it's an absolute substantive error, Your Honor. But,
No, but I'm just saying, there are
Yes.
cases about, like, the limitations of a court's ability to do that, and I don't recall your brief making any argument that that's the problem here.
I didn't make that argument that that was the problem, but what the problem is that, and this is a chicken and egg situation in terms of which mistake came first or which mattered first. But as far as the mistakes that I'm talking about that Judge Biggs remarked upon, Mr. Jennings had some concerns about a defect in the original indictment. Now, legally, lawyers at this point can sit back and say, that didn't affect the case, it shouldn't have been important,
It
yet.
was sloppy at best, I mean, at least, I mean, how do you add in heroin when heroin's not even on the table?
Correct, Your Honor.
And then how do you screw up the indictment a second time after you've already screwed up the indictment once?
Because you can't get the schedule right. I mean, cut and paste should have precluded that. Nevertheless, Judge Biggs was in the courtroom when she addressed Mr. Jennings about his concern about the indictment defect. She was able to observe him, to look at him, discern whether he was sincere in his beliefs, whether he was truly concerned, or whether he was trying to manipulate something. And if the court will indulge me, I would like to read to you some of the comments that Judge Biggs made. I'm not sure that Judge Osteen read the transcript that contained. You read them. Okay. So it's really troubling. It's a mess. I can't understand how it happened. If I were him, I'd be very upset. If I were him, I'd look at it, and I'd have some real serious issues about the people who are running this prosecution. So not only did she find at that point that Mr. Jennings was reasonable in having concern about the indictment defect, but she absolutely validated his concerns. And after a judge tells you what you've done is absolutely reasonable, if you act on that, that is inherently reasonable. And Mr. Jennings acted on that in this case by discharging his lawyer the next day, because it can be inferred from the record that his lawyer had told him that it wasn't a big deal, that there was a defect in the indictment. And again, we can reach that conclusion as lawyers, but Judge Biggs knew who was in front of her. She knew that he was the only person in the room who wasn't a lawyer, who didn't understand this, understood that Mr. Jennings is a person for whom mistakes have consequences, huge consequences. When Mr. Jennings makes a mistake, he goes to prison for 20 years. He doesn't get any do-overs. So, of course, he was baffled when he was in the district court, and the prosecutor had made this mistake that even back at the time of the initial appearance, the magistrate judge pointed it out to the prosecutor and said, this might be something you need to supersede or correct the indictment on. And so it's absolutely reasonable that Mr.
He didn't
Biggs...
get sentenced with a mistake on the mistake.
Excuse me, Your Honor?
He didn't get sentenced on the mistake. Well, he caught the mistake before the trial, right?
Yes, that was absolutely
Say
finished.
he went to prison for 20 years. It's like he went to prison for 20 years on a mistake.
No, I'm not referring,
It was corrected. The problem here is the length of time and the Speedy Trial Act. I mean, but
yes,
whether he ultimately went to prison for something he did, I mean, he kind of did. I mean, because he went to trial, he had a nice clean indictment by the time they actually
Yes.
tried it. The jury found him guilty, the judge sentenced him.
yes, Your Honor, let me clarify. I don't mean that he went to prison on the mistake of the government.
The mistake you're saying is, the mistake is possession with an intent to distribute fentanyl.
His criminal
That's
conduct.
the mistake that you're
His
referring to.
criminal conduct. And from his perspective, that's a pretty serious mistake that he made in his life. So in any event, not only did the judge make that mistake as a clear error of fact, Judge Osteen, but Judge...
What was the clear error of fact that Judge Osteen made? I'm totally tracking how upset Judge Biggs was about this, but then...
Judge Osteen later said that Mr. Jennings was unreasonable in being concerned about this matter, and that it led to frivolous conduct on his part in discharging his lawyer.
Lawyers, right?
Well, he did discharge more than one lawyer, but the only material discharge of a lawyer in this case that impacts the speedy trial calendar was the first discharge of the lawyer.
Because by the time of the later discharges, we'd already run? Is that
Exactly.
I thought he was, Judge Osteen.
I'm sorry.
Go ahead, Clerk Clapper.
I'm sorry. The second lawyer was appointed, let me look at my timeline. There's so many lawyers,
sure.
Your Honor.
It seems to me that the second lawyer was appointed on March 4th, is that right?
That's correct. And that's when the 60-day critical period of delay commenced,
When he was represented by lawyer 2.
when he was represented by lawyer 2.
Where does Judge Osteen say he was unreasonable in being upset about the indictment? I'm totally not getting that. I have that his objections end up being largely irrelevant and ultimately resulted in large part to a frivolous delay of these proceedings. I can't quite track that, but.
Well, I'll point to the court to page 147 in the appendix, where he said at this point, he talks about, counsel, Mr. Jennings being without counsel at various times. He says, any breakdown in communication with counsel didn't result from the government's errors, but instead resulted from defendants' frivolous responses to those errors.
This would include, like, telling your lawyer to stop harassing me when they want to talk to you about legal proceedings, and then you say, stop. I mean, at some point he does that and says, they're bad. What is the thing the Gen Zs would say? Stop bullying me by coming to talk to me about my case, right?
Your Honor, where that happened was Mr. Jennings believed that after the hearing with Judge Biggs, that Judge Biggs had discharged her lawyer at that point. That's what he reflects in his motion. And then that lawyer came to see him 2 more times, and so that was confusing and felt like harassment to him.
But to be clear on Judge Harris's question.
Yes.
It seems Judge Osteen was talking about his conduct with his lawyers, not the indictment.
Well, he talks about the defendant's unreasonable and unfounded positions contributing to the necessity for substituting counsel. And so one thing led to another. Ultimately, the judge relied on the fact that he discharged counsel as being unnecessary and that set other things in motion.
I mean, it's a fairly long oral opinion.
Yes.
I really sort of thought the thrust of it was he says, look, there were a lot of mistakes here, including the government, and that what he really thought was contributing to the confusion around this 2-month period is that there's this executed plea agreement out there, and the defendant is, perhaps because he is in between lawyers, doesn't make his intentions clear. Does he actually want to go to trial? Is he going with the plea agreement? But I didn't really, at least where he's, what I kind of think of as like, here's where I'm explaining what went wrong here. I'm not getting quite so much of a flavor of, man, this guy with his like frivolous responses to government errors. I mean, I hear what you're saying, and it's long, and there's a lot of discussion.
There's a lot. And in fact, at one point, the judge says to, Judge Osteen says to Mr. Jennings, or says to everybody in general in the courtroom, his lawyers if his lawyers try to explain something to him and he doesn't take that to heart, it's on him. But it's not on him. Judge Biggs found it wasn't on him, that he legitimately misunderstood. If I might talk about the second clear error of fact, Your Honor, and that happened where the judge accurately identified the 2-month period between March and May as being the critical period of delay. And interestingly enough, it said that it wasn't going to take the government's word that resulted only from inadvertence, but it was going to look at the general case and find that out. And so it came up with a theory where the things that Judge Harris, that you mentioned, might have contributed to some confusion or some delay. The problem with that finding, Your Honors, is that the government never claimed that. They filed a written position on their speedy trial, on the speedy trial issue. Their primary argument was that they didn't think there was a violation, that, the excludable time didn't exceed. The non-excludable time was far less than 70 days. But when it got to, said, well, but if you do find there was a violation, the circumstances don't support a dismissal with prejudice. And then they ran through linearly sort of what happened in the case, and it got to the point about the 60 days and said, we indicted them, but we didn't get them arraigned until more than 60 days later, and that's on us. We're responsible for that. And so they weren't looking to an excuse to say we were confused or something else. And indeed, the record shows, and so that's something where it looks to me that Judge Osteen went back and filled in some gaps and made an excuse on behalf of the government. Now, previously,
Judge Osteen also said it was partly the court clerk's problem, right? The judge basically was like, we are here today because all 3 legs of the stool screwed up. The defendant was like, the stuff about the defendant, the government didn't proactively act, and the court's clerk also sort of dropped the ball.
But, Your Honor, the defendant didn't screw up. People gave him some, the judge vindicated his position.
Well, he didn't,
He didn't
I want to go back to the
screw
thing that Judge Harris asked, that it is pretty clear. There was a signed plea agreement.
There was.
And there was just hanging out there for a while, and he didn't communicate to the court that he wanted out of his plea agreement. That is on him. Now, maybe it's on him because of a misunderstanding between him and his agent, his lawyer, but from the court's perspective, the defendant never said, I want out of my plea agreement.
Nevertheless, around the same time, the indictment
But that's true, right? That's true. There was a period of time where the defendant never said, I want out of my plea agreement.
But he never said he was pursuing it either. It was Judge Biggs who suspended the Rule 11 hearing and sent everybody home. He didn't ask for that, but that happened because she wanted to hear from the original AUSA who drafted the indictment.
In terms of, again, this is a criminal defendant facing serious charges who is justifiably confused and angry about these mistakes the government keeps making. I posit all that. But in a how the world should have worked situation, at some point, if the defendant no longer wants to plead guilty, it's probably incumbent upon and fairly easy for the defendant through counsel to say, just FYI, I know we are talking about a guilty plea. That's off. I'm going to trial. I would like to preserve my speedy trial rights. In an ideal world, that's what would happen, right?
And if the government had said that's what led to the delay, we could credit that. We could believe it. We could say that was why they had the delay. They never said that was the reason there was a delay. That excuse was provided for them by the court.
And this is because the government said, we'll take responsibility for the 60 days. I mean, those two things don't seem entirely inconsistent. And in fact, the district court didn't think they were inconsistent. It did say it's on the government. They really messed this up. But he also said there were some unusual circumstances at the time, partly because of this plea agreement that's hanging out there, and then there's a superseding indictment, and so there's some confusion. And he says that might have confused the clerk's office. It might have, just caused some confusion.
And I see my time is running low. Can I give you just one more answer about how this confusion came about? So the judge actually, Judge Osteen, went back and did his own research about what happened in the clerk's office with regard to this. And if you've read the transcript, you've seen this, where he said that, both the court and the government acknowledged it was the government's responsibility to get this thing on the calendar. At the end of February, a scheduling person from the U.S. Attorney's Office emailed the court and said, hey, we need to get this thing on the calendar for one reason or another, but we need to get it on the calendar. For 2 months, no response came back from the court, but neither did the government follow up. So there's just, I don't see any reasonable basis to conclude that the government thought it shouldn't be calendared, because they asked for it to be calendared, but then didn't follow up for 2 months when that didn't happen. Anyway, I will come back and speak with you on rebuttal. Thank you.
Thank you, Ms. Hayes. We'll hear from Mr. Inman.
May it please the court, Stephen Inman for the United States. This court should affirm the district court because the district court did exactly what 18 U.S.C. Section 3162 required of it. That was to consider the 3 factors, among others, that are set forth in 3162 for whether this dismissal of this indictment should have happened with prejudice or without prejudice. And that is a decision that the court made after a sound, extensive review of the record in this case, after making substantial findings that are found at Joint Appendix 133 through 148 with regard to the Speedy Trial Act, and that is a decision that's left to the sound discretion of the district court.
Counsel, can I just preface this by saying you are very, very lucky the district court didn't dismiss this indictment with prejudice, because I think there are lots of district court judges who would have dismissed this indictment with prejudice.
I will be the first to admit, Your Honor, this is not the finest hour for the United States with regard to this indictment or with regard to the delay. Just as the district court took it seriously, our office takes the delays seriously. I do think that it's important to recall that the district court hadn't just been confirmed yesterday when he heard this opinion. As the district court says in his findings at page, I believe it's at 146 and 147, the judge essentially says, 142, in my experience, 14 plus years as a district judge and 20 years of practicing in this district beforehand, the parties have been in the past very cognizant of speedy trial responsibilities. This is not a slow docket, and something like this happening is very unusual. In other words, the judge says, look, in my experience over almost 35 years in this district, dealing with the U.S. Attorney's Office, dealing with the clerk's office, dealing with the defense bar, everybody operates and moves cases judiciously and speedily. And so the court is making that assessment in terms of considering not only the facts and circumstances of this case, but also in determining whether, looking at the impact of reprosecution, it's important in deterring the government to dismiss the case with prejudice or without prejudice. And the court is saying,
if there's reason to believe it's a systemic problem. What I'm sort of positing is whether that's a legally permissible consideration or not. Because it's certainly not one of the factors listed in the statute that you're supposed to consider.
Well, Your Honor, I think that
First screw up is free. First really, really bad screw up is free because you haven't screwed up really, really bad before.
No, Your Honor, I don't think that's it. I think the third factor, which is where the court made this analysis, is on the impact of a reinstitution of the prosecution, how that would impact the administration of justice and the administration of the Speedy Trial Act. And so when the court is considering, hey, how much do I need to deter the government? Because that's one of the things that the Supreme Court says in Taylor is, look, if we dismiss every single indictment that goes past 70 days, that is going to deter, for certain. That will
Super
deter.
deterrence.
Super deterrence. But it would also nullify the first 2 factors that Congress has set forth in 3162, the seriousness of the offense and the facts and circumstances that led to the dismissal. And so the court has to balance all those. And the court did balance all those. And of course, it found at page 133, the seriousness of the offense, the first factor, no one disputes. The defendant to this day doesn't dispute that this is a serious set of offenses. Obviously, it's serious given the sentence he ultimately received. But it certainly is something that the court factored into its determination as it was required to do. And then the second, the lengthiest portion of the court's findings found from pages 134 to roughly 142 or 143 of the joint appendix on the second issue, the facts and circumstances. And the court highlights three issues with regards to the facts and circumstances, as this court's already noted. First is that the clerk messed up, essentially, in not setting this case down for arraignment. Second, and where the court spends the most time discussing this, is that the government screwed up and not keeping an eye on this case for a 60-day
the government
period.
screwed up, by my count, no fewer than 3 times. Is that right?
Well, Your Honor, we certainly did not.
Indictment 1, mistake. Indictment 2 somehow fixes that mistake but introduces a new mistake, which is, I will say, of all the things in this case that is baffling to me, is that you screw up the indictment once, and in the course of fixing the indictment, you introduce a new mistake in the indictment.
What I would say, Your Honor, in terms of.
I just can't imagine, we all make mistakes. I've made plenty of mistakes, but like the mortification that must come after mistake 1 is like, we need to make absolutely certain that indictment 2 does not have a mistake. God forbid doesn't introduce a new mistake that wasn't in indictment 1.
And
How
again,
the heck does that happen?
Inadvertence, Your Honor, I would say. And again, I'm not here to.
That's a very kind way of describing what strikes me as at least gross negligence and probably plausibly worse than gross negligence.
Well, the one thing I would say to the court in response to that, because it is, again, not the government's finest hour with regard to the drafting and the care and review of the indictment in this case, and then the superseding and the second superseding before we finally got it right. But this is not something that inured to the prejudice of the defendant. And I know that, Your Honor.
Except that this individual who's thrust into the criminal justice system facing a very scary prospect of really bad things happening to them, who's told that he has all kinds of rules he has to follow, and if he breaks any of them, really bad things happen to him, and then is told that the government screwed something up and then screwed something up again. I don't know. It seems quite plausible that a totally reasonable person, especially a layperson, would be extremely upset and confused by that. And that it might adversely affect his relationship with his lawyer when his lawyer tells him, doing what they're supposed to do as an officer of the court, you're like, I get it, this sucks, and I'm sorry they screwed this up, but we can't do anything about it, and the defendant is frustrated when his lawyer tells him that. This all strikes me as totally plausible behavior.
Well, Your Honor, what I could say with regard to what his lawyer told him is that his lawyer did discuss, and we know this from Joint Appendix 56 through 58, when his first lawyer moved to withdraw, he told the court, and this is not contested in the record anywhere, Mr. Chamberlain, his first lawyer, told the court, look, we discussed, me and my client, me and Mr. Jennings, we discussed this discrepancy between the fentanyl and the heroin in count 1 and count 3. What did Mr. Chamberlain do on Mr. Jennings' behalf? Mr. Chamberlain negotiated a plea agreement to count 4. And it's a remarkable plea agreement, and I suggest that it is an indication that the government acknowledged its screw up in negotiating that plea deal, and that Mr. Chamberlain took advantage of that because he negotiated a plea agreement to the only count in the indictment that capped Mr. Jennings' exposure at 120 months, and that was what count 4 did.
First come to recognize it had made, want of a better term, the screw up or the mistake here. When was this brought to the government's attention?
Your Honor, it was certainly brought at Mr. Jennings' initial appearance when he appeared before the master
That might have
judge.
been the first time, and then once that occurs, what would be the course of conduct? I mean, I would think as a prosecutor, you look down and you see an indictment and it has something patently wrong in it. It just seems at that point, I mean, the case is for the government to prosecute. Something ought to be done. I mean, there are a lot of ways, and I mean, you do superseding indictments and the whole bit that goes with that. And I'm not so sure it's so benign that, you know, you can you sort of pattern this, well, this is, Judge Osteen had been there for 34 years, and this is not the way it's done. Well, he says on J8 120, this looks like it's a problem. Like this business of delay coming from having to correct indictments seems to be a problem. Certainly Judge Biggs alluded to it. I don't know what goes on in the Middle District, but I think that comes into play, and maybe it's sloppiness, maybe it's inadvertence, maybe we, whatever term we want to use to play it down or play it up, but it's serious business to a defendant. I mean, in a criminal court, this is not some little, to substitute heroin for fentanyl is pretty serious stuff. It certainly changes the character of stuff, and then call fentanyl a particular scheduled drug when it's not. That's pretty serious. I mean, that alters how long you're going to be in jail, and also comes into play, how do you negotiate when you got the wrong stuff? I mean, what were your considerations? And should that be a negotiation tactic. That is, I put heroin in there, and I tell you when I'm gonna cut you a break, because there shouldn't be heroin in there. Should that be? Because then you're starting up here when you really should be starting here with the negotiation of a plea agreement. So, I mean, at the end of the day, there's something going on here. Your trial judges recognize it. The issue before us is whether Judge Osteen should have dismissed this with prejudice or without prejudice. What is our review of that?
Your Honor, this court's review and the standard is abuse of discretion. And so what I understand and what I think the lesson from the Supreme Court in the Taylor case and this court's cases is this court is to look to see whether the district court considered the three factors that are set forth in 3162. And the problem that the Supreme Court identified in Taylor is that the district court didn't consider the three factors under 3162. And if this court is satisfied that the district court reviewed those three factors, made findings based on those factors, then it comes to an abuse of discretion standard. And again, that's not to say that this court on a de novo review couldn't look at the same record and say, as you indicated, Your Honor, that the issue with this is so grave and so concerning that I have to dismiss this with prejudice.
Do you think it would have been, I was thinking about this, but I assume if the district court had dismissed with prejudice, the government could have appealed?
I believe we could have appealed, Your Honor. I'm not certain that we would have.
Do you think you would have been likely to win on appeal?
I'm sorry?
Do you think you would have been likely to win that appeal?
I do not think we would have been likely to have won on the appeal, Your Honor, because again, I think it's a decision that's entrusted to the sound discretion of the district court. And so just as we lost, I believe it was the Hardin case that my colleague across the aisle notes in her brief, that was a case where we appealed. And this court said, tough luck, government.
So can I ask you about the 2-month period? Now, so that I want to bracket for a moment your friend on the other side's argument that the district court sort of accepted an argument on behalf of the government hadn't actually made. But what exactly was the government doing during these 2 months between when he gets a second attorney and when he was arraigned? Why did that take 2 months to get this guy a new arraignment?
Your Honor, I think it...
What was the government doing?
As the court identified, Your Honor, it was mere inadvertence. There was nothing in the record to suggest that the government was doing anything other than failing to recognize that this defendant had not been brought back before the court for an arraignment.
They did nothing.
For 60 days, Your Honor,
Simple answer.
we did nothing. We did nothing.
Yeah, I think that's a good answer to it.
Well, and it's
So
the truth.
now, like, remove the, like, your friend on the other side said that the district judge said, like, maybe it was because of the plea agreement and maybe because the clerk's office was confused. Did the government argue, like, any of that before the district court?
I think the government fell on its sword and said essentially that we didn't get this done over the 60-day period. And then it fell to the district court to say, as the district court did at Joint Appendix 141, I simply don't see anything in this case, based on the record before me, of any type of bad faith or intentional misconduct or delay on behalf of the government.
What would that be? I guess I've been thinking about this. I know the cases say bad faith. Like, what would it... Like, what would that be?
I think if
it strikes me
perhaps-
that almost all the times that people have Speedy Trial Act violations, it's because, and look, I have been a government lawyer before I had my current job. Like, people screw things up. Like, but what would bad faith be as opposed to, like, I don't know, I screwed up and I didn't pay attention and I thought someone else was handling it. Like, I don't know what bad faith would even be in this context.
I think certainly bad faith could be if we had sent emails that said, hey, let's throw this guy in a dark hole, see if we can tune him up, soften him up a little bit, maybe it'd be more receptive
We'll
to our
hold him as long as we
agreement.
possibly can.
Yes. And here, I think the reason that's not a plausible thing to think that the government thought is because this defendant had a plea agreement. And not only did he have a plea agreement, he had an immensely beneficial plea agreement to him. As the court knows from looking at the pre-sentence report and from the trial, the defendant admitted his conduct. He didn't just admit the fentanyl that he possessed at his house that day. He admitted that he had been selling heroin for 4 months and re-upping 2 ounces every 2 to 3 days. He admitted that he bought the gun that was found at his house near those drugs. And so this is a defendant.
He admitted he was selling heroin for 4 months?
He admitted he was selling heroin. And I'll say this in terms of the fentanyl-heroin discrepancy, even the defendant was confused about fentanyl and heroin. And so if this court looks at those portions of the pre-sentence report, Joint Appendix 935 and 936, the defendant tells the police when they come to serve the search warrant, he says that he had a personal use bag of heroin in his pocket. What he identified as heroin turned out to be fentanyl when the lab tested it. The special agent, the expert from the Drug Enforcement Administration, Stephen Razik, who testified at trial in this case, indicated that basically heroin and fentanyl are essentially indistinguishable until you have a laboratory test. All that to say that there's a reason that people are dying in this country from fentanyl overdoses, because a lot of times they think they're buying heroin, and a lot of times the people selling it think they're selling heroin.
But in this instance, what was found here was fentanyl at the time here. There wasn't any heroin involved in the process, and clearly the inclusion of heroin in an indictment was, I guess, a mistake. That was a massive error.
It was.
I mean, that's what we're dealing with here. I mean, yeah, we can talk about how bad heroin is in fentanyl, but that's not our issue for today. Fentanyl, the issue here has to do with the speedy trial, the delay that occurred during this period of time. And, I think, end of the day, however this case comes back, the facts don't reflect very well on the Middle District in terms of how things are going. And that pains me greatly, being a North Carolinian myself, being also, you've got 3 outstanding trial judges here, and they picked up on this. I mean, Judge Osteen picked up on J120, and certainly Judge Biggs, and I'm sure Judge Schroeder picked up on this. And they're just trying to do the best job they can do, and this is not very hard to do. I mean, this is the simpler thing to do, and that's what you call the right thing, to treat even hardened criminals with respect of what the criminal system allows them to do. Just, you got all the cards are there. I mean, just do the job. And it puts you to have to come up and argue. I'm not even sure you had this case below, and you might have, I don't know. But it puts you in a position to come up here and argue to us. You write an opinion. That does not look good on paper. That thing stays in the book forever and ever. So I'm pretty confident somebody's having a discussion down there. We won't see this type of case again, I hope, and not from any of the states in the Fourth Circuit, anywhere else, but we won't see this kind of thing.
I would certainly hope that's true, Your Honor, and as the criminal chief for the United States Attorney's Office in the Middle District of North Carolina, I certainly take this case very seriously. I certainly don't want to see
If we see it again, I can tell you, probably even be harder now for you to argue this case. If we see this stuff again, I mean, this business of pattern and stuff, it's like, wow, it's almost like, as Judge Hyden alluded to, you got a mistake, and lo and behold, you make another mistake that's not even on the first one. A new one comes on the second one. He says, who's doing this stuff? And it's pretty straightforward stuff. I mean, you don't have to dream up an indictment. There are a lot of ones out there. You've got a bunch of these things out there. Someone can sit and copy them and do it right. But anyway,
Just a very
judges.
quick question on a separate question. So your colleague asked that we consider her client's pro se briefs, given that he feels strongly he would prefer to represent himself. And I think we've already said we're not going to do that, but in light of his wishes, your colleague thinks maybe we should take a look. And I guess I'm just wondering if you would have any objection to that. Or maybe you'd want to file something supplemental.
Your Honor, I think if the court wants to consider his briefs, we would ask to be, maybe have the opportunity to respond to those. I think that, again, in the Court of Appeals, different than obviously in the district court where parties have the opportunity to represent themselves, here this court depends on learned counsel to be able to advise the court on issues that those lawyers believe merit review. And again, I think my colleague across the aisle has certainly hit upon a good issue. Obviously, this court is engaged with this, and again, we take it seriously. But I think that given the fact that there have been ample number of issues that have been raised in the briefs in this case, I don't believe that the pro se briefs ought to be considered. But if they are, I would ask that we be allowed to have an opportunity to respond to those. But if there are no other questions from the court, I would ask that the court affirm the district court's findings. Thank you.
Thank you. Mr. Inman, Ms. Hayes, you have a few minutes in rebuttal.
Thank you, Your Honor. I have a few things I want to address. I just very quickly want to address the issue of Mr. Jennings' informal briefs, and I want to note specifically that the court twice gave him permission to file those briefs. He didn't just supplement after I filed a brief, the court twice gave him permission.
You
And
got something in that brief that's better than the brief you sent us?
I raised the issues I thought were the best ones, Your Honor. Nevertheless,
What do you think in his brief is gonna add some flavor that's different than the wonderful brief you sent us?
I frankly think it's a matter of showing respect to Mr. Jennings and you forced counsel on him. I think it was a good thing to force me on
Do you
him.
think there's anything legal in that brief there that has any so much merit that it would influence this court? You're probably gonna say no, because that would tell you should have put it in yours, right? So that's not true.
I think I picked the best issues to present
bet
to
you
this
did.
court, Your Honor, but I don't think it would be a great hardship for the court to read his briefs.
That's fair. Do you, I guess, though, fair enough. Do you take issue with the government's suggestion that if we're going to consider arguments that are in only a pro se brief, the government should probably have an opportunity to
Yes, of
respond to those?
course, they should have an opportunity, and they actually had an opportunity. He filed informal briefs. They sat on their hands and didn't respond to them.
Except counter argument.
So there you go.
Except our practices with respect to what happens in district court sometimes, we have
Right.
said repeatedly, there is no such thing as hybrid counsel in the Fourth Circuit. The government could reasonably understand our practice to say you're not required to respond to things that are only in a pro se brief because there's no such thing as hybrid representation.
They're not required to, but they're not forbidden.
That's right.
And also, they were pending before we appointed counsel.
It was in a break between appointed counsel. He was appointed counsel, counsel withdrew. I'm the third or fourth appellate
When he
lawyer.
filed, I'm sorry, when your client,
Yes.
Mr. Jennings filed
Yes.
his informal briefs with us, it took a minute before we said we want to appoint counsel for argument.
Exactly, Your
So
Honor.
those briefs were sitting there, and the government could have responded to them.
Exactly, Your Honor. I want to make just a few more points very quickly. Judge Harris, you had asked me a question about if the Judge Osteen actually found Mr. Jennings to be unreasonable. At page 146 in the joint appendix, he says, defendant's unreasonable and unfounded positions expressed in his letters with respect to defects in the prosecutorial process, i.e. defects in the indictment, leave me little doubt that those positions contributed to the delay. So yes, he did specifically say that he was unreasonable and his positions unfounded. Next, I'd like to say that this is not an ordinary case where the government was just, inadvertent for a little bit. This fits within the definition of a truly neglectful attitude, which the Supreme Court and Taylor said could be a basis for a with prejudice dismissal, and which in Hardin, the court affirmed a with prejudice dismissal on the basis that there had been a truly neglectful attitude, even though there was no bad faith and no intentional delay.
So here, what's the truly neglectful, other than the length, what is the truly neglectful attitude other than the sheer amount of time?
It starts with the defect in drafting the First Amendment. It was sloppy. It's neglectful. You don't have to have heroin in there when there's no
But that's
heroin
not a
involved.
defect related to the Speedy Trial Act. That's screwing up drafting an indictment.
No, but it's still a matter of having neglectful behavior, truly neglectful behavior. He did that. The magistrate judge recognized it. They didn't do anything to correct it. They only corrected it after the district judge said, I need you to come in here and explain to me how something like this could have happened. Rather than embarrass themselves, go in and give that explanation. They superseded the indictment and introduced a new error in the superseding indictment, which Mr. Jennings, he may not have a great deal of education, but he is a detail-oriented man and he's involved in his representation. And he was facing a lot of time. He noticed that. It bothered him. It created more angst on his part. That's non-trial prejudice that occurred to Mr. Jennings. And then only after all of that happened did the government just sit back for 2 months and not do anything while the case languished. So that's a pattern within this case, and it's truly neglectful attitude on the part of the government where, as you mentioned, you mess up his case once, don't you think you'd be more careful? No, the government kept making mistakes, and these things fell on Mr. Jennings. And I would mention the dismissal without prejudice, it really didn't have much of an effect at all on the government. Yes, you go back to the grand jury for a little bit of time, you present the same case again, you come back with the same indictment. But Mr. Jennings, By the time May rolled around, may I just have one more minute, Your Honor? By the time the May 4th rolled around and the judge had found that there were more than 90 days of non-excludable time had passed, Mr. Jennings was entitled to be released pending trial. There's a statute that says that. You can't detain someone for more than 90 days pre-trial, taking into consideration excludable days, and they're entitled to go home. But instead of going home and awaiting trial, no, the government had the opportunity to just stop it and start it over and start the speedy trial clock all over again. Mr. Jennings suffered severe non-trial prejudice on that basis, and the government suffered very, very little. Thank you, Your Honors.
Thank you, Ms. Hayes. I note that you are court appointed, and I also note, personally, I know that you're not just court appointed, you are